हेलो। माइक चेक। हेलो।
हेलो 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 माइक चेक। हेलो 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 चेक 1 2 3 माइक
1501.
After referring to the NCLT rules, which seem to have been followed in this case, we said that issuance of a notice to the authorized representative of the respondent bank was not enough to satisfy the mandate of the proviso to section 7(5)(b) of the IBC. The IBC being the substantive legislation relating to the application filed by the respondent bank under section 7 thereof. The notice to cure the defects therein necessarily had to be given under the said provision, and compliance with the rules independently framed for the National Company Law Tribunal was not sufficient. We are of the opinion that even though the registry of the NCLT issued process under Rule 28 of the NCLT rules, the same was insufficient as there was no communication of a notice under the proviso to section 7(5)(b) of the IBC at any time. We therefore find no error having been committed by the NCLAT in holding to this effect. However, the NCLAT ought to have asked the respondent bank to cure the defective affidavit, at least at that stage, instead of ignoring the same and directing the NCLT to proceed to hear the company petition on merits and in accordance with law. To that extent, the NCLAT was in error. The appeal is accordingly disposed of, directing the respondent bank to cure the defects in the company petition, including the defective affidavit, within 7 days from today, and the National Company Law Tribunal, Ahmedabad, shall thereupon take up the matter for hearing in accordance with law and due procedure.
Item number 801.
801. We are informed that the matter is tentatively directed to be listed on 2/12/2025, shall not be deleted from the said date.
Item number 802.
Not to be deleted.
May I mention item 57? But I'm seeking a short accommodation.
We'll have to wait till the matter reaches. Please.
My lord, with your lordship's permission,
Yes.
can I, my lord, mention that BOCW Act, which your lordship had,
Yes. Yes.
my lord, your lordship had given us 1 week's time to file written submission.
You want more time?
Yes, my lord, Miss Gunjan Sinha, who's appearing with me, her mother-in-law, my lord, passed away on Saturday morning.
Very
So
good.
instead of 1 week, can your lordship just give us 2 weeks time, my lord?
Make it 2 weeks.
I'm
Please inform the outside.
Yes, sir.
Item number 1.
Lordship,
Yes.
this matter, the counter has to be.
Counter is filed now.
Still yet not received.
It was filed yesterday.
It was filed on Saturday.
Saturday. Oh,
Filed. So
Did not get any
you didn't receive it.
So let me inquire. If
These
you
are housekeeping
send the
issues,
email,
not-
then let me check.
Very short counter has been
Very
filed.
short
but,
count has been filed.
No, but you still need to share it with them.
Lord, I have already shared it, but these are.
And we don't
housekeeping
have the
issues,
proof
we'll solve
of actual service here because the registry doesn't insist on filing a email copy or
it. Lord,
how do you communicate it?
Lord, email me.
Email. So we don't know whether he's received it. You sent it to the correct address.
Kindly list it on 28th,
Very
no, 28 now,
Non-counsel for the petitioner states that he has
Friday.
received a copy of the counter filed by the state. Learned counsel for the state shall furnish another copy to the learned counsel for the petitioner. Rejoinder thereto, if any, may be filed by the next date of hearing.
28th November.
He's in jail still, so
28th November, Friday. Coming.
28th November.
Thank you.
28th.
This matter I am seeking.
Counter affidavit is not.
Lordship, kindly take on record my appearance, Lordship. I
Yeah.
could not file, please.
Counter affidavit is not yet filed, Ms. Patil. We didn't
You have
receive
not
it.
a copy.
You've received a copy of the counter?
I have
They've also not received.
I have no information.
The office report is dated 21st and it says counter not filed.
We filed it yesterday, that's why,
Very
Malad, you may say, we
Learned-
bring it on record.
Learned ASG states that the counter was filed yesterday,
Yes, Malad.
filed yesterday, e-filed
Yes,
yesterday.
Malad.
However, we do not find the same on record.
He's in DC,
Learned
Lordship.
counsel for the petition. You shall also be furnished a copy, Then counsel for the petitioner shall also be furnished a copy of the counter. You need to file a rejoinder, you will have to explore that.
Short week.
Rejoinder there too, if any, may be filed by the next date. How much time would you
Is it 2
require?
weeks or 1 week? Not much.
Based on 8th December.
Obliged.
My lords, item 3, my lords.
Yes.
Expect 3 opportunities, my lord.
No counter.
They have not filed a counter, my lords.
Counter.
This also we filed, Manoj.
Oh, with regard to that house being,
Yes, my lords.
We
But-
have filed on 21st in this, Manoj. I'm sorry, it's
Not
not
on
on
record.
record.
have you received it?
Yes, my lords.
You-
I'm carrying the copies, my lord.
No. You've received the counter?
Yes, my lords, I've received.
Two things we are saying, Manoj.
No, but we don't have the counter, Ms. Bhatt.
My lords, I,
What have you said in that with
Two
regard to
things
this
you
house?
said, Manoj. One is that the ownership of the premises does not have an impact on the NDPS.
But how do you pin it on him then?
So, Manoj, on that.
Was he there at the place? when
Yes,
you
he
found-
was there. He says that he has taken the premises on rent. These are unauthorized occupations going on in these.
Then how would he take it on rent?
Manoj.
If it's unauthorized occupation, whom does he take it on rent from?
Mafia, Manoj, that is all.
No, but there's a lease deed. in
No,
his-
but-
Manoj, no, that is his statement. His statement says that he is para 3, if you're not.
How do we
yes,
go by what you squeezed out of him
No,
in
Manoj,
terms of a confession?
Manoj, permit me to then show what is there in, against him. One is, Manoj, the recovery of the contraband. Second is recovery of the pistol, and third is CDR.
Or he was present at the spot?
Yes, Manoj. So if I can show to your lordship the recovery.
You need to file a response to that? To the counter, this is a counter to the IA, is it? Counter.
In the charge sheet also at page 51,
Hmm.
the ownership was a matter which was awaited, if your lordship sees
No,
at
but
51.
we have not seen the counter because it's not yet been put up. If you had the privilege of looking at it, then you will have to tell us whether you need to respond to it. If you do, then we'll give you some time.
My
Otherwise,
lordship
you
may
want-
have a look, my lord.
No, but you are caught on the spot with all these drugs.
On the not at the first instance, subsequently.
What do you mean?
First, the first accused one, if your lordship just have a look. We came little later,
Ritul Ali was not there at the spot?
on the same day, but subsequently.
What do you mean
I'll
subsequently?
tell your
You
lordship.
walked into a trap.
Which page? Page 35, your lordship have a look.
Page 30.
First, it starts from. First, if your lordship sees a 33 para 3,
Yes.
first, when they came to the place, one Moinul Islam was there. And your lordship will find
Right.
that page para 3, page 33.
Yes, that's
And that-
right. Then when do you come in? Page 35, para 9.
Para 8.
Para 8. Para 8. Two persons arrived.
In the meanwhile.
This is house number B by 71.
Right.
That's right.
Now, the A1 Moinul Islam has been granted bail by the High Court.
Moinul Islam is supposed to be your driver.
Man, and he was the first who was there, and he has been granted bail by the High Court. And your lordship would find that para 65, page 51.
Hmm.
Even when filing the charge sheet, ownership was a matter of doubt. Page 65, para 65, page 51.
Hmm.
Letter was sent to DGM NF Railways for ownership detail of the seized place, so and so, so and so. Reminder, in this regard, is awaited. No, in the additional document, we have filed the reply response. In the IA that we have filed,
Yes.
if your lordship sees, page 8,
Yes.
first the government of India seeking the requisite information from the railways. That your
Yes.
lordship will find at page 8.
Very well. The reply is at 9.
And the reply is at page 9,
Hmm.
that is 20th May 2025. In terms of your letter under reference, it is to inform you the railway quarters, actually, it should be written as so and so, has been lying vacant since 2004. These officers want to inform you that there was a lot of unauthorized occupying the vacant quarters. In this regard, a letter was received from DGM NF Railways dated 1/11/22 regarding occupation of railway quarters by unauthorized person. Accordingly, a reply was sent to DGM via letter dated 23/11, which is enclosed for your kind information. If your lordship sees those two letters at page 10 and 11, 10, that is 2022, unauthorized occupation of railway quarters by railway employees.
Yes.
With reference to above, furnishing herewith below following information to your good officers for appraisal of statutory audit, so and so. With reference to point 1, the following table is shown. And this house, your lordship will find at serial number 51 at page 11.
The number seems to have changed somewhat. B71 is now E71-B. Is it the same house?
That's what they say. In the previous letter, if your lordship sees at page 9,
Yes.
second line, in terms of your letter,
E71.
just inform me, actually it should be written as E.
E71-B.
And that your lordship will find that serial number.
Dimple Saha.
Dimple Saha.
So,
Now, he's been in custody for almost 3 years.
and what is your explanation for going to that place? You were caught there. And Moinul Islam is your driver.
He has been granted bail, my lord.
No, but he was inside when
He
they
was the
knocked
first
on the door.
person, yes, my lord.
And he says that you and that other gentleman, Anwar
I and the other driver came subsequently, my lord.
Atikur Rahman.
Atikur Rahman, accused 3.
Atikur Rahman is also your driver.
My lord, so we came
So-
together, my lord.
You're not a driver though.
I'm not the driver. Now, my lord, so far as A1, that your lordship will find,
There seems to be an it's.
there is no criminal antecedents.
No criminal act.
No antecedents, but the status of trial also your lordship should know, Manas. Out of 12 witnesses, 4 have been examined. And there are total 3 accused, Manas. Only 1 is on bail. And 2 and 3,
Atikur is also inside.
they are both in custody, Manas. And my respectful submission would be, your lordship may permit me to show what is there in the charge sheet query. Because one is, Manas, your lordship already saw at page 35, para 8 onwards.
Yes.
He arrives in this Innova at the site and the search and seizure is going on.
Yes.
And please see what is he saying? On being asked, they told your name is so and so, so and so. House was there, search and seizure was going on. Place belongs to Jitul Ali. He works as driver. Then Moinul Islam told that Atikur Rahman is also driver of Jitul Ali. Moinul Islam further told that Jitul Ali and Atikur Rahman come to this house every day. She so and so, Ayush showed his ID card to Jitul and so and so. Shared information. Then please see para 9. Search in the Innova in which they arrived. During search of Innova Crista car, 1 pistol with mark so and so, 1 empty magazine was recovered from the dashboard, glove box of the Innova Crista so and so.
This is the car that they came.
This is the car that they came in.
Only
So,
the
Manas,
contraband that was found in the car.
Sorry?
Contraband was not found in the car, man.
That's
No
correct.
doubt, but
And please see the
all
contraband.
these parts put together, Mr. Goswami, it's very
No,
difficult.
my lord, I see.
Contraband also.
Look at the amount
No,
of.
I'm not, my lord, I'm not going to the penny.
Tablet,
Your lordship,
79.
1,000 kgs of heroin,
Why not?
16 bottles of.
Not 1,000 kgs, 1 kg.
Sorry, 1.2.
1.028 kg.
So full bouquet of. Malab,
my lord, he,
They're catering to all levels of addiction. They've also got cough syrup there.
my lord, the main person who was first caught, my lord, he has
No,
been
but
granted.
with these quantities being caught there,
Moinul Islam, your lordship will see at page 90.
he's your driver. That's perhaps the reason why he's.
So, my lord, on grounds of arrest, your lordship is
19 is the.
90, which is the page? Bail order. 98 it starts, my lord.
98.
My lord. Then 108, 109. Para 19, man. There also he was for more than 2 years. I am more, my lord. And at that point of time, also only 3 were examined. Para 18 onwards. It cannot be denied that the accused is behind bar for more than 2 years, 6 months. From the date of arrest till date, the
Only on the ground of the length of incarceration.
Length, also only 3 out of 12. Today also only 4 have been
But we still need to give some respect to section 37. With these kind of seizures, if we let people off lightly, what kind of signal would we
The person who was there in the first instance, maybe my driver, he is being granted bail. I am, my lord, behind bars for more than 3 years now, my lords. Your lordship may put me to any condition. There is no criminal anticipation.
Not at this stage, Mr. Goswami.
My lord,
Remain for some more time.
Your lordship will give me some liberty to approach the court.
We'll say only at this stage. We are not inclined to interfere with the impugned document at this stage. Especially if it's according to this list.
Some liberty to move against.
That's why at this stage would indicate that after some time you can perhaps.
If your lordship could indicate.
That should be indicative enough, Mr. Goswami.
Deep down.
Yes.
Please, Lord. It's a regular bail, my lords. There were 2 incidents, my lords. One at.
They have filed a very detailed counter.
Yes, my lords. My lords.
Online.
Please, madam.
Oh. Yes. How do you establish that it was 2 separate incidents?
Yes, my lords.
This
My lords,
video
at
which
page-
shows you
page-
pelting stones from the terrace.
Yes, my lords. At page 60, my lords, of the charge sheet, my lord.
Page?
Page 60, my lord.
60. Yes.
Para 4, my lord. 4th
Yeah.
line. During that time, accused Iqbal, who is Nambardar of the village and respectable person, told us to resolve the matter amicably and not to repeat this kind of act in future, and on social grounds to have a discussion in the evening, as Akbar and accused person live close to each other. That is why we decided for evening for everyone's convenience. Now, my lord, the second incident which comes at on 5/4/2024, being last Friday, the holy month of Ramzan, all the family members went to offer Friday prayer at village so-and-so and mosque so-and-so, came to our house and
No,
went.
but the first incident, where does it
Yes,
mention
my lord.
that
That
you
is
were on
at
the roof and
page 59, my lord, para 2, my lord. Yes, my lord. On 5/4/2024, around 10 a.m., the accused began abusing at Akbar's house and accusing his goat eating their leaves and plants starting quarreling.
No, there's no mention of anyone being on the roof and.
Yes, my lord. That's
pelting
what.
stones.
Now, my lord, the role, my lord, on which this FIR has been registered, at page 61, my lord. Third line, my lord.
Yes.
Farooq was holding the hand of Uwais so that he cannot save his life. Haseen and Iqbal grabbed Uwais from behind and make him fell on the floor. Rafiq alias Rafa grabbed Uwais' hairs with both hands and made him fall down on the floor. And Nadeem stabbed on Uwais' chest with a knife which he was holding in his hand with the intention to kill him, due to which Uwais was flooded with blood. Daraj stabbed Uwais on his back with knife which he was holding in his hand, and Quair struck him and with danda on his body. All the accused persons have been beaten, deceased mercilessly. There is no recovery from me, my lords. There is no injury caused by me to any to the deceased as well as to the complaining party, my lords. My lord, there are total 13 persons were named in the FIR. I have been named in the supplementary statement that was registered the next day, my lords. Out of which 9 additional persons were also named in the supplementary statement. My lord, total 22 accused were there, out of which 14 were exonerated, my lord. Charge sheet has been filed against 8 persons, my lord. There is no criminal antecedents against me, my lords.
Where is the mention of you in the charge sheet?
My lord, that is, I have been arrested just as an accused, my lord. That
there must be some mention of you in the charge
yes,
sheet.
just a name, my lord. That is there. Yes,
where is that?
Exactly. That is
Then the concluding paragraph.
that yes, my lord. And at page 58 as well as the concluding paragraph, my lord. That's it. There is no role against me, my lord.
Page 58, you're there.
Just a name, my lord. That is just a name. The subject part and the concluding paragraph have been named.
There's no specific allegation.
No specific allegations against me has been attributed to me, my lords.
Yes, Counsel for the State.
Please, madam.
What have you said in the counter with regard to the specific overt acts attributed to you?
My lords, with respect to this, my lords, my instructions are, my lords, that there is two families, they are in quarrel with each other.
Don't give us general information. What have you said about this man in particular? In the charge sheet, there's no specific overt act attributed to him. But somewhere I read that you said that he was standing on the roof and pelting stones on the people.
Please, my lord. And the photographs have also been annexed, my lords.
What time was that video? According to him, there were 2 incidents on that day, one in the morning, one in the evening.
Please, my lord.
Then what time is the video? Is it the morning video or the evening video?
Morning.
That is the specific case, that the video which is showing him pelting stones was in the morning, which is not the fatal attack. The evening attack is the fatal one. What did you say about that?
With respect to this, there is a in the comments, this particular aspect has not been pointed out.
That is his entire case. What do you mean by
In fact, I have called the IO. If
counter without meeting the point.
please, if lordships, I have called the IO for taking direct instructions in order to have the discussion. If lordships can just give me 2 days time, I'll come back, with the specific.
Pick it up on Friday.
Please, Milord.
Not Friday, Thursday.
Grateful.
Thursday. At the request of the Land Council for the state.
Please.
Item number 5. Lord's permission will be granted to withdraw the SLP as the petition has been admitted by the Honorable High Court by the order dated 16th of October 2025.
What this is?
My lords, there's a issue of POXO in this, and the only theory was PW3 who had seen the petitioner.
Last scene.
So last scene theory corroborated by nothing else, my lords. This was only under section 25 and 26 of the Evidence Act, where there was a confessional statement before the police. That is the reason.
If the state comes, then we'll ask you to come back again. The council for the petitioners have permission to withdraw the special leave petition, as the petitioner has been acquitted by the High Court in the pending criminal appeal. Norms are pending in the criminal appeal from which the present case arises. The condoned petitioner as well as the special petitioner accordingly dismissed as withdrawn.
Item
number 6.
May I please, my lords? My lords,
Yes.
this is against the grant of bail, we are for the state.
But merely because statutory bail is granted and thereafter you file a charge sheet, it does not automatically mean that you ask for cancellation.
No, absolutely. Therefore, my lords, I'll take you, my lords, through the merits of the case. My lords, kindly see, he's a
You
fact.
have to seek cancellation of that bail.
My lords,
You've not done that.
no, we haven't done that.
So far as the grant of the statutory bail is concerned, that was justified.
Yes, that was just.
Then against that order, what is the SLP that we are going to
I
do?
bow down, my lords. The
Then-
only thing is that.
If sufficient grounds are made out for you to seek cancellation of that bail, go before the High Court then.
Yes, my lords.
Or the trial court, whatever it is.
Yeah, my lords.
So far as the grant of the bail is concerned, there's nothing for us to say.
Now with liberty to move the High Court,
Counsel.
record that otherwise.
Counsel for the petitioner seeks permission to withdraw this special leave petition, reserving liberty to the petitioner to approach the trial court of League High Court for cancellation of the bail in the event sufficient grounds are made out therefore.
Of subsequent developments,
No,
whatever
we
way
don't know
one
what.
wants to put it.
That judgment is there of this court, which said that you don't need violation of the bail conditions alone. You can even go on the merits if sufficient grounds are made out therefore. So on the basis of that, you can still ask the court to look into it.
My lords, I'm so great.
Item number 7.
That also delayed condone the petition as well as case. Yes,
Lord, this is for anticipatory bail, my lord.
well, you come on, when was the order passed? May, but the FIR is of October 24. So 1 year.
There is some delay, my lord.
1 year, why should we entertain this?
My lord, kindly see, he is.
By now, they might have initiated steps against you also.
Lord,
The FIR is 1 year ago.
Lord,
Charge sheet was filed in December 24.
this charge sheet is filed. Lord, everybody is on bail and I am a cancer patient.
But even then, if suppose they have initiated proceedings under what is that now, 84 BNSS,
No,
then we don't know.
That is not.
We don't know. You may not disclose it,
At least,
but given this passage of time, we'll have to think about those aspects also. No question of granting you anticipatory bail
at
in
least,
relation to a FIR lodged 1 year ago.
Milord, kindly see the facts, Milord, kindly see.
Not on facts. We are telling you that it's not possible to grant you anticipatory bail in relation to an FIR filed 1 year ago, in which a charge sheet was filed in December 24. Sorry. Delay condoned. However, we find no good ground and reason to interfere with the impugned judgment, given the length of time that has passed since the registration of the FIR and the filing of the charge sheet. Especially petition is accordingly.
Item number 8.
Well, 8 is an application for bail.
It's code in hospital. Notice. We'll issue notice. Issue notice returnable on 18 December. Service will be effective for all modes, including best.
Item number 9.
Delays by delay control. 7 days. Item 9. Grant of against the grant of bail.
Please connect it.
Someone is there?
Item number 10 along with 58.
Lordship, I am praying for past governance.
Item number 11.
Please, Milord. Milord, this is a regular bail, Milord. Milord, he's been in custody for more than 2 years and 3 months, Milord. Milord,
These
there are,
similar cases.
Milord, I'm on bail on 3 similar cases. Milord, rest of the cases are for
You
1.
seem to be making good use of the bail order though, by committing one more.
Those were earlier, Milord. Not that after registration of this very year. Those were earlier, Milord. Those
So
cases.
now you've turned over a new leaf.
Milord, there is no other case apart from this which has been registered now. Milord, kindly see, Milord, it's the entire payment. The allegation is that they have made the payment in cash. Now, initially,
Punjab and Haryana, this is a regular feature though. Everyone wants to send his son or daughter abroad for a job and they get duped like this.
Milord, but the primary allegation was against accused number 3, who's Mohit. What the complainant they said that they met him first and thereafter he made us meet the petitioner Helen. Now subsequently, if Lordship would go to the FIR, he
So returnable on 5th January.
was in the meantime, yes, the standing counsel, Lord.
Service may be services effect. Sorry. Permission is granted to effect service of notice upon the learned standing of the designated counsel for the state of Punjab and Haryana. Which one is it? Haryana or Punjab?
Haryana.
Haryana.
DP of Legends.
Number 12.
Be pleased, Lordships. Lords, this is arising out of NDPS Act. Admittedly, Lords, even as per the case of prosecution, the substance which has been seized weighs 11.51
Less than
gram,
commercial.
less than commercial. So it's an
More than the small quantity.
yes, it's an intermediate quantity. But he has been behind bars since Lords last 14 months. 27th August 2024 is the date of raid or the seizure. And in wee hours of 28th of August, FIR has been registered. Investigation is complete, charge sheet has been filed, my lords. And there are no criminal antecedents of the present petitioner. There are 2 other co-accused. I may not claim parity, my lords, but they have been granted bail because they are apprehended only on statement of the present petitioner. And subsequently, my lords, released on bail on regular, enlarged on bail. Of course, charges are not framed as of now.
There are around 19 witnesses cited. Also, but as of now, there is no list under section 294 submitted to the special court. Twice earlier, the application was filed. Once it was withdrawn. After charge sheet, it has been rejected. The first order should get the reasoned order The impugned order is of 11th of July. There is one reasoned order which was passed.
Which page is that?
That reasoned order is at page 162, my lords. So this was the initial order passed. This is after filing of charge sheet, of course. 10th February, it was pronounced. Lordship has that at page 162. Though it was tried to argue that this is a case of parity, that was rightly distinguished, I would say. At page 164, last but second line, the distinction is that the present petitioner was apprehended while he was in actual possession, when it was not the same case so far as other accused persons are concerned. So after this, after some time, I again applied for bail. That was turned around by the special court as well as by the Honorable High Court, perhaps.
Round though,
My
which
lord.
I have noted though.
My lords.
The latest judgment with regard to compliance with section 50 CRPC.
My lords.
Grounds of arrest.
Grounds
That
of
you
arrest.
raised before the sessions judge, page
That was raised.
173.
Yes, that has been turned on at page 170.
On the ground that you were informed.
My
It
lord.
was not in keeping with what the
Was
bench
filed.
said in that.
File obvious for that, my lords. That was
Issue
turned on
notice.
saying that there is already a compliance.
Issue notice returnable on 5th. And service shall be effective.
5th January, your lordship has said.
Yes.
But may I have the liberty to serve the standing counsel, my lords?
Service shall be
If
effective.
the order also indicate, my lords, if they want, they can file a counter because this date will
Service shall
be
be-
almost after 4 weeks.
State is at liberty to file its counter. Don't say liberty. The notice would be sufficient indication that the state would be required to file a counter affidavit by the next date of hearing.
But it's time to value.
Item number 30.
May legal lordships.
Yes.
Lordships, here is a case where a history sheeter, if you see the criminal antecedents, first thing lordship will see one thing, how he has played around the High Court. Kindly have he has first filed a quashing petition, and then when he withdrew the quashing petition, and then filed a bail petition. Would lordship kindly come to the quashing petition, just come to the cause title of the quashing petition.
What about the other accused who's been granted bail on parity is now?
Parity, I have a strong, I'll tell you, lordships. But before that, one thing I'd like to just, please for a moment, lordships.
Which page?
Kindly come to the cause title at page 70. This is the quashing petition filed before the Allahabad High Court.
Yes.
Kindly mark it Ajay Pal Gupta, aged 37 years, son of Rampal Gupta, and see the address of Uttar Pradesh. Now kindly have a look at page, the cause title of the bail petition. Page 105.
Yes.
Ajay Pal Gupta as a Sonu Chaudhary, son of Shri Shobha Ram. Please do compare these, both of them. And see the address here. Khajuri Khas, New Delhi. He has played around every authority, every person. Even before the Delhi High Court, before the Allahabad High Court, he does this.
This case was filed at, I see it, in
This
Allahabad, but showing the
Father's
Delhi.
name is different. Father's name is different.
Father's name also is.
Yes, lordships. Please see the father's name.
What was the other one? I didn't notice the father's name. Rampal
Gupta. And here it is.
Rampal Gupta, Sonu Chaudhary.
And this is Shobharam.
I see. Alias Sonu Chaudhary, son of Shobharam.
Now, he has disclosed 4 cases, but he has not disclosed the fact that he has jumped bail.
This is the one in which you find those Aadhaar cards and everything.
Yes. He has got
Where is that?
many Aadhaar cards, many PAN cards. But the most startling thing, lordships,
Oh, I see.
most startling thing,
Yes.
though he has disclosed 4 cases, but he has not disclosed the fact that he has jumped bail. Would lordships have these judicial orders? Please.
He's jumped bail also.
Yes, jumped bail. Lordship will kindly see. This is FIR 229 of 2017. This is the case pending in Delhi High Court. And we have annexed that. Lordship will see his own, he says about 4 cases. I'll just connect it. Please kindly come to the criminal antecedents at page.
So now the name has changed to Sonu Seth.
Sonu Seth. Now,
Sonu Chaudhary, Sonu Seth.
now please see what is last 2 paragraphs.
How many names does he have?
We don't know. And if he is released today after 2 years, he has absconded for 2 years. Now see what the court orders. It's the first order I'm placing, 25/125. Reports produced. Thereafter, it is stated by the learned APP for the state that the accused Munna and Sonu are intentionally and deliberately avoiding process of the court to prolong the process with request to issue NBWs against them.
The same Sonu according to you.
Yes. No, he has talked about this case in his petition.
I see.
He has talked about this. So with such a person, such conduct,
To notice.
he is still not been released, lordships. He is still there. So lordship will stay the order.
12th November.
Yes. Yes. On instructions, I'm saying he has still not been released.
Issue notice returnable on 2nd February. Service shall be affected by all modes including industry. We are informed that respondent number 1 deliberately showed his father's name differently in different proceedings, perhaps to gain some undue advantage. That apart, he is stated to have, he jumped bail or he was absconding? He was absconding.
82 proceedings have been now initiated. The next order indicates that.
He was absconding in relation to FIR number 229 of 2017.
Pending in Delhi.
Which police station was that? Gita Colony.
Gita Colony police station.
Gita Colony, registered with Gita Colony Police Station in Delhi, as is evidenced by the order dated 26/4/2025, passed by the learned Judicial Magistrate First Class within that -2 within brackets East Karkarduma Courts, Delhi. We are further informed that respondent number 1 has not yet been released from prison pursuant to the grant of bail by way of the impugned order. If that be so, the said order shall not be given effect till the next hearing.
I'm so very good. Very good.
Madam, sir, item 40. Madam, I'm seeing short accommodation matters kindly on Monday, next Monday.
Right?
Madam, in this matter, Gandhi Singh also is appearing.
Mr. Luthra,
But we have to.
you're changing.
Not Madam, Mr. Luthra has to appear, but we could not get the appointment. That's why we could not engage.
The request of the council for the petitioner, the matter is at the list on next Monday. You want?
Yes, madam. Next Monday.
Next Monday.
Month of this, madam.
Please, ma'am.
Let us then.
Yes, ma'am.
And counsel for an appeal.
Yes, ma'am. It's an appeal against the
Counsel for the appellant seeks an adjournment on the ground of ill health. But this argument of what? Limitation not commencing. You will have to perhaps convince us on that. Otherwise, the delay is uncondonable.
My lord will satisfy. My lords had actually condoned as in relisted a matter, a connected matter last week. This is on the 17th of.
That was within time, or that was also beyond time?
That was beyond time.
That was also beyond time.
Those appeals are connected. Would my lords kindly list this on the 12th of January together?
12th of January. Don't tag it. Let's say 12th.
Item number 16.
So great.
The High Court has denied him.
Colossal lethargy.
Milords, 25 years, Milords.
Well, colossal lethargy, what do you expect?
Milords,
In
the
fact,
reference- Milords,
giving
Milords,
you the benefit of that enhancement itself, you should be thankful for. How
Milords,
do you
what has
get
happened, Milords?
interest?
The evidence has itself started in the year 2014.
You don't pursue your reference.
Milords,
You
these
just
are-
let it go, dismiss for default in 2018.
Milords, may kindly appreciate.
Then you file a writ petition in 2024.
Milords, the original landowner, Milords. Milords, the present petition.
But how are you entitled to seek interest when you sleep over the matter and let things lie for decades together?
Milords, but may kindly appreciate, from 2000, the reference was filed, Milords. It was registered in the year 2006. Milords, for these 6 years of delay, Milords, petitioner is not responsible. That is administrative.
That doesn't mean that your delay is to be just wiped out.
Milords, but
It is the exchequer who has to pay you this interest for a period that you slept.
Milords, that has not been done by the High Court. Straight away, Milords, from the date of filing of reference.
No.
Milords,
Colossal lethargy is what you have been
High Court done, Milords. I am not denying that some days may be deducted, Milords. Milords, what has High Court done, Milords? From the date of filing of reference itself. Delay, Milords.
Sorry.
Milords,
Delay condone, however, we find no good ground and reason to interfere with the interim judgment.
Milords, there is a harsh order, Milords, because this petitioner is, Milords, grandson of the original.
You will get the benefit of the enhancement. Be satisfied with it.
Milords, may kindly, Milords, may at least direct, Milords, that the delay period be calculated by the reference court, Milords.
No.
Because it is the
The
trial.
High Court has already decided it. Where is the question
High
of
Court has not considered
leaving that issue open? Sorry, Counsel.
Obliged.
17. This matter.
Yes.
Milords, I am ready to pay the amount. However, I need some time.
You already had enough time. You asked for 30 months installment.
Financial difficulty, Milords, I am facing right now.
The High Court permitted you 25 monthly installments instead of 30.
I am ready.
And you committed default in the first 2 months itself. You paid that 12 lakhs and nothing else.
Milords, financial difficulties. I am
That doesn't mean that you keep on buying time. How long will the bank also wait?
I am in the hands of Milords.
No, sorry.
Please, Milords.
Your sympathy we cannot, and that too with a 376 days delay in filing. Sorry, Counsel. We find no good grounds made out to condone the inordinate delay of 376 days in the filing of the special petition. That apart, we find no grounds to interfere even on merits. The condone delay petition and the special petition are accordingly dismissed.
Item number 18.
Mayor, please.
Here, Mr. Balbir, so the registry has not raised it. In fact, I just spoke to the Registrar Judicial about it. Please look at your dates. You have filed this appeal on the basis of a free of cost copy, certified copy. If it is a free of cost certified copy,
Yes.
you are not entitled to deduct the time taken by the registry of the NCLAT to furnish you that free copy. It is only when you apply for a certified copy that you can deduct that period.
Well,
Here you have conveniently deducted that period. You will be within time, but there needs to be a condone delay petition.
Well, I'm sorry, I have
You
not
will,
examined.
you will still be within time. You are not barred by time because you are within that condonable 15-day period.
Well, I will.
But you need to file a condone delay petition.
I will do that. I might do that.
But that's only to let you know about the technical aspect.
Please, Lord.
On merits, however, we
Well, I'm
interfere
grateful.
with this matter, Mr.
Yes,
Balbir.
briefly, I can give a background, if subject to my lord's ruling. So the personal insolvencies and the corporate insolvencies are covered in 2 different chapters. Section 94 deals with, and the process is different from Section 7 process, which is
Yes.
there. In this case, against the corporate debtor, because the principal debtor is a corporate debtor, goes on, and that is completed on 12/1/2021. After that, my filing is 3/4/2023. So the trigger of the proceedings against the principal debtor ends on 1st of January 2021. I am within time. What they say is because SARFAESI proceeding against the corporate debtor
Not
started.
just the SARFAESI.
Yes.
They invoked the guarantees against you in 2016 and 17.
No, that is through the filing section 13 before this thing, because
Once those personal guarantees are invoked,
yes,
you're obviously put on notice
no,
that the clock
that's
is
what that I was saying. The difference is to
and you don't come up till 23.
Yes.
If
So there is
if we count it from 2017, also it expired in 2020.
First is the section 94. Section 94 came in the statute book in 2019.
Very well.
That's the position which has been there. Prior to that, only
at least from 2019, then 2022.
I could have gone for, but I have something more to say. When I filed my application, I had the lenders who were the corporate financial creditors and the operational creditors. What the tribunal has done is, instead of looking at the operational creditors, solely looked at the financial creditor, which I agree. I can debate on this, which date is there. Kindly see my application, which is page 348 for a minute.
348.
348, which is on
volume 2.
Volume 2. This is my section 94 petition.
Very good. Yes.
And as a statutory form starts from page 360. And it is in multiple parts. Part 1, I'll come specifically to first just to show that my petition is at 348.
Yes.
The form starts at 360.
Yes.
And part 3 is the detail of the debtors, creditors, which is there, which starts from page 366.
Yes.
On the first, now kindly, if my lords can kindly go to 368, the second financial creditor, Indian Bank, because this is a consortium lending. And I take it for a minute that what my lords are saying is right. 368 is the second consortium lender. Third is the page 370 is the third, because there were 3 consortium. Fourth, the operational creditor 372. Now kindly see this, fellas, that in this case, the debt due is serial number 6 and 7. On the page, the serial number 6 on this. Vigyan Arora, the total debt is 413. 6 says that the debt due was 24/10/2022. Date of default is 24/10/2022. I need not succeed in case of to meet the limitation all the creditors. Even if the one creditor is outstanding, section 94 kicks in. Now, what is the fate of the remaining can be taken care because there's a complete resolution process which is there. You can't ignore to say that even if one is within limitation, the section 94 is to be admitted. Section 94 is the only kickstart. Now, you can't say that I will look at only the financial creditors and I will not look at the operational creditors. And this is part of my original application. RP agrees with me on this. RP submits a report under section 100, which says that no, this is to be entertained and there is a jurisdiction and competence of this court. I can show RP's report for a minute.
He recommended, yes.
He recommended, and more than recommendation, 506. Because tribunal is functus of it.
File your condoned delay petition.
I'm grateful, I'll file it.
And counsel for the petitioner seeks an adjournment to enable him to file a condoned delay petition in relation to the filing of this under section 62 of ABC.
May I request if my lords can issue notice subject to my filing and undertaking. Every day I may not be able to explain this every day.
We condone the
very well.
matters.
I take that. Yes. Well, I'll file in a week's time, Malasthi.
1 week.
And my lords can give a date.
Next Monday?
Next Monday, my lords can keep it. I'll do the needful before that.
Correct.
I'm grateful.
Number 19.
But may I just mention to your lord.
Against this 30th November 2008.
No, that's because I was not party.
Badge of.
No, I was not a party to this.
Your members would have been.
No.
There were quite a lot of
So that's why we filed a review.
Mr. Sibbal,
that's why we filed
just trying to breathe life into a dead body.
No, it's not dead at all. It's not dead at all. But then we can demonstrate to your lordship. We'll file an affidavit. But we have not. I'm sorry to say, Mother.
It can't be reopened and revisited.
No, but I have
said again and again. Look at the order.
Kindly see the question, Mother.
The assembly against that judgment was dismissed in 2022 after condoning the delay. So even then,
I'm not a party to that.
You can't say that I'm an association. Therefore,
no, I'm not an association.
You are a Kotwar association.
No, I was not being a party, Mother.
You are not a party. Your members must have been party.
No, they are not. I will demonstrate.
We don't even have the details of.
All right, I will file. I'll file an affidavit. Please allow me.
Numbers.
Allow me. I'll file an affidavit to show that I was not a party in any sense of the word, neither the association nor I. That's why I filed a review when I got to know. It's only last year, mothers, that they came to me and said that you have no right. Allow me, sir. Allow me to just
It's completely wrong. Judge says I'm not party.
At some point of time, you need to let sleeping dogs lie.
The question is, I got hereditary rights.
Where is the question? All that has been considered, dismissed long ago. And now you suddenly come up with a review petition after.
1 minute for your lordship. 1 minute of your lordship's time. Just hand over this, please. Just here. Now, what was the question of law referred to the division bench? Just see that.
Your review petition was in 2025 in relation to a 2018 order.
That's correct, because I got to know in 2024.
There is a question of your claiming ignorance of what.
But he has admitted that the order says that I was not a party.
You are not a party. Your ignorance claim is to be taken with a bad.
That's the finding against me. But if only on delay,
that is what we are finding.
All right.
All right. In the face of it, you are trying.
All right, Mother, just see that question of law for a minute at page 4, which is referred. Just see that. Whether a coachwar holding service land under section so and so can be granted Bhumi Swami rights over such service land in view of the provision contained. We say, yes, you're right. But what have they considered? This is not service land. So they have given findings beyond this, Maharaj, which have affected me. I am not holding service land. My right this is
the. All of you were in the same boat.
No, Maharaj. No, there is a judgment in our favor.
You're not inclined to interfere.
Right.
We find no ground.
Just dispute or delay then, Maharaj.
To condone the inordinate delay in the filing of the special leave petition.
Have another chance.
Inordinate delay of 2,409 days in the filing of the special leave petition against the primary order dated 30/11/2018, which was in fact tested before this court in a batch of special leave petitions, which were dismissed by order dated 25/2/2022. The special leave petitions accordingly dismissed. So we can dismiss this and then go. What? Late handing over of side, what is it that you want?
What was supposed to be completed?
You don't hand over the site is the finding.
That's the finding.
There is a question of not sitting on that finding of fact. 34 court, 37.
Even the hindrance does not say.
Mr. Raghupati, award is valid. There's no question. We find no good ground and reason to interfere with the impugned judgment passed by the High Court. The special leave petitions accordingly dismissed.
Item number 9.
May I please, Lordship?
Yes.
A short explanation because I wanted to seek for an adjournment, then but due to technical difficulty, I could not log in, my lord. And the AC is leading in this matter. The Lordship may kindly have it on
Council 6, Council for the petitioner 6 in adjournment. Less strong. Or on Friday, next Monday we'll take. Next month.
Obliged.
Number 10 along with 58.
My lord, my grievance is that the High Court has not followed my lord's directions. Please see page 283. What was my lord's direction?
283.
That's my lord's order.
Yes.
Follow Om Prakash. And now please see para 33 of Om Prakash.
Yes.
May I read that?
Yes.
And then I'll show my lord para 15 of the judgment. That's all. So my lords have said follow Om Prakash. And Om Prakash says at para 33, bearing in mind the aforesaid principles of law, the endeavor on the part of the court therefore should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately the convict stands fair chances of acquittal. If the answer to the above is to be in the affirmative as a necessary corollary, we have to say that if ultimately the convict appears to be entitled to have an acquittal at hand of this court, he should not be kept behind bars for a pretty long time, till the conclusion of the appeal, which usually takes a very long time. However, while undertaking the exercise to entertain whether the convict has a fair chance of acquittal, what is to be looked into is what is something palpable. To put it in other words, something which is very apparent or gross on the face of the record, on the basis of which the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. The appellate court should not reappreciate the evidence at the stage of 389 CRPC and to try to pick up a few lacuna or loopholes here and there in the case of the prosecution. Such would be a correct approach. Now, what happened in the instance case, please come to paragraph, page 6, paragraph 15. Now, this is the 7th time they had moved a bail application. 7 bail applications have been rejected. Now, what the court says in para 5 is, after hearing submissions, the fact which surfaced before this court are that no gun is seized from the possession of the appellant, whereas it is the specific allegation of the complainant that the appellant also wielded gun. 1 second, sir. Why? It is explained they are absconding after the incident for nearly a year. There is award given on their name. If you catch somebody after 1 year, of course he destroys all this evidence. Number 2. Between specific period between 6:30 and 9:30 p.m. is not successfully explained by the prosecution that why no Dalit Dehati Nalish was prepared when the police reached the spot and the brother of the deceased has not taken deceased to the hospital, nor he was present on the spot when the spot map was prepared as per admission of complainant Dashrath, as well as the fact that the eyewitness Balram did not refer to the presence of Dashrath when incident took place. Sufficient contradiction, omissions surfaced in the testimony of Dashrath, PW5, who are other eyewitnesses as well as investigating officer. Specific allegation to open fire is over Banti and Lakhan. Appellant is 70 years old and only suffered 4 to 3. Now, my answer is, now please see on delay and FIR is explained at page 55, 195. Page 195 by the trial court.
Yes.
Within 3 hours of the incident, the complainant Dashrath submitted a written application as Exhibit P12, regarding which he had also revealed in para 15 of the cross-examination that he had got this application written by Munendra, who is the elder brother of his elder brother Rajendra's son-in-law, and had signed it and given at the police station. Witness Dashrath rejected the defense suggestion that his report was not written by Munendra Singh. In para 14 of the cross-examination, witness Dashrath also revealed that he had reported the incident at 9:09 p.m. It's not a.m., Lord, it's p.m. At the university police station. The police had arrived at the scene only 20 minutes after his brother's murder. And Munish Rajoria and 2-3 policemen had come to the scene of the incident. Learned Defense Counsel argued that Muninder Singh's name is not even mentioned in the application form of P12, and Muninder Singh was not included as a witness in the case by the prosecution. The application form for Exhibit P12 later has been deliberately exaggerated and recorded in a written statement, which is not credible. This argument of the defense does not seem to be acceptable from the point of view because Manish Rajoria evidence is not of a more effective nature than Dashrath evidence. Generally, it is not possible for a person who has seen his brother being murdered in front of him to write the report himself in a short interval of the incident. The application form P12 after the incident is well supported by the evidence of complainant Dashrath, Manish Rajoria, PW14, ASI Badam Singh Baghel. Thus, on the basis of the above entire evidence discussion, it is believed the first information report was lodged immediately in the case, that there is no material delay has been caused in registering the first information report. Thus, the application from Exhibit P12 and FIR Exhibit P13 and the inquest report Exhibit P26 written on its basis are found to be well authenticated. Now, all this is now disbelieved in para 15.
No, but there seem to be contradictions with regard to whether you were an eyewitness to begin with. PW6 says that you were not present there. You are projected as an eyewitness.
Yes, I am projected as an
eyewitness.
Not
There's also some discrepancy as to whether you.
There are 4 other people also.
You took your brother to the hospital or not.
No, but
if you did not take your brother to the hospital, why was there so much more?
There was four other eyewitnesses on record which the court has not noticed.
No, but do they speak of your presence?
Yes, they speak of my presence and they speak of the murder.
Who is the other eyewitness?
Please see page.
According to the High Court, PW6 and the other eyewitnesses, all of them say that you were not there.
No.
That you seem to be a planted.
No, please see PW17 Kailash at page 179, para 30.
179.
Para 30.
Yes.
So this is a case where they are going in a car, they are surrounded by this syndicate, and with continuous firing, they are killed on the spot by spray of bullets. And within 10 minutes, the family members arrive. Police also arrives. Everybody is there, sir. That's what I'm trying to say. So please see page 179. On this point, the testimony of witness Kailash, prosecution witness, is also worth noting. He was examined as an eyewitness. In his chief examination, while particularly supporting the prosecution version, he stated that he knew the deceased Ram Khiladi, also recognized accused Betu Sharma and Omkar Sharma, but did not know the other accused. He stated around 7-8 years ago, on the 15th of that month at around 6:30 p.m., he and Balram were following Ram Khiladi in a gypsy. As they reached Silver State, firing suddenly took place, which was targeted at Ram Khiladi, and his vehicle came to a stop. This vehicle also stopped. The vehicle was being driven by Gandharva. The shots fired at the vehicle by Betu Sharma and Omkar, these are the two people who've been granted bail, hit Ram Khiladi. Some bullets also came towards the vehicle, but they hid inside. So they were not hit. He saw Omkar Sharma and Betu firing.
Now, where does he speak of your presence?
So please see 232.
He doesn't say that you were present there. So there seems to be some amount of manipulation.
No.
That is the reason why the High Court says that this is a fit case for granting suspension of
five eyewitnesses. Apart from this person, there are 5 eyewitnesses. What I'm trying to say, it's not a case as if they were only relying on Dashrath. There were 4 other eyewitnesses who have been considered by the trial court. And this is a case of a murder in the most daring way. Please see para 84 at page 211, sir.
Yes.
It starts from para 83. It is worth noting that although Dashrath stated that the spot map was not prepared in his presence, this does not necessarily mean that he provided no information about the crime scene to the station in charge, Mr. Munish. This specific question was not even put to Dashrath during his testimony.
What about these other eyewitnesses, PW7 and PW?
They have named them.
5 is you. PW6?
They PW6 at page 181.
He's denied by that.
Balram is the only one who turned hostile. But PW7, then and then others have named him.
So he's turned hostile. He doesn't say anything.
Damodar is at page 185.
But he also names Omkar.
Oh, yes.
And Betu.
Yes, that's what I'm saying, sir. After turning hostile, also is naming Omkar and Betu.
Issue notice. Returnable on 6 January. Service shall be effective by ordinance.
But could it be returnable in 4 weeks?
January.
Very. I'm so okay.
Item number 21.
Said the High Court has partly allowed my appeals.
What more do you want?
No, my lord, the
It's
same
only a
instance,
question of fact now.
no, my lord, the same instance at pay at exhibit 45, which was produced before the reference court. My lord, that was not at all considered.
How much is the value there?
Lord, as per my calculation, for irrigated land, there should be 6,028 rupees per hour. Half only has been given. Even not half. Like Jirayat land, my land.
What is the date of that sale deed?
Sale deed, yes.
What is
this
the
is
date?
27th of January 2004. Well, with prior to the section 4 notification dated 27th of July 2005. The High Court notes that there was irrigation facility. The land is irrigated land, but sale deed has not been considered. For that purpose, page 9 and 10 may kindly be considered.
Yes.
But page 9, may I read from
Where is the reference to this sale deed that
yes,
you want?
page 9, according to Mr. So-and-so. Page 9, according to Mr. So-and-so,
Exhibit
reference
45.
code, or yes, relied sale instance exhibit 45 and worked out market value of the acquired land. However,
What is the date of 44?
44, I'll just come in. May I just read by the time? For reason that the sale instance at exhibit 44 is more proximate to the date of preliminary notification. Legally speaking, no fault can be found in the approach of the reference code while relying upon the sale instance at exhibit 44, considering the proximity to the date of notification. One more aspect highlighted by the reference code is the sale instance at exhibit 45, which depicts that it was purchased by the adjacent landholder, possibility that he offered higher price cannot be ruled out. Further sale instance at exhibit 45 is only for small piece of 7R, whereas the sale instance at exhibit 44 is for 43R land. The reference code has
What is the extent of your land?
Not my land.
Which is acquired now?
Small parts of land because it was for a storage purpose, storage tank purpose.
How much?
7R 22. There are in fact 5 matters. Only one has been listed today.
Your land, how much was it?
Yes, I'll just. Yes. And my lords, can my lords just consider page 10 for a moment about irrigation facilities.
Mr. Counsel, the choice was between exhibit P44 and P45, right?
Yes, yes.
So the High Court has assigned reasons for discarding exhibit P45.
Yes.
Saying that it is in respect of a small piece of land and the neighboring agriculturist has purchased, therefore he might have paid the higher price.
Might have.
So therefore it has relied on exhibit P44. What's wrong with
the possibility?
44 fixes the value at 3,000 per hour.
No, for Jirayat land only. For Jirayat, and ours.
Yours is irrigated.
Irrigated, yes. Page
irrigated
10
land is 3,000 now.
No, but it must be more than that, my lord. Page 10 for a moment.
You only have 45. You don't have anything else.
Page 10 may kindly be seen. Yes. It shows about the irrigation facility. However, there is no reason to accept such contention. Claimants have failed to bring on record any material that acquired land had perennial irrigation facility. The evidence on record would indicate that irrigation facility like well or borewell was available in acquired land, but crop pattern does not disclose perennial irrigation. Further, the compensation is assessed by the reference code relying upon previous.
So that is also in doubt whether you had perennial.
For that purpose, may I just cite 2 cases?
No.
Of this
where is the evidence of perennial irrigation?
Well, the High Court says the evidence on record would indicate that irrigation facility like
In the award, are you granted any compensation for pipelines and?
no. Deductions were there. There were
Towards reductions?
pipeline and borewell.
That has now been compensated.
Yes, compensated.
No, but in your land, what was there?
For that,
In your land, what was there?
but there was borewell at page, the valuation report is at page 113, P7, pre-pipeline, then page 115, irrigation well, page 115 may kindly be seen. And at the bottom, present value of
pre-pipeline? Pre-pipeline.
It is, it says only pre-pipeline.
We don't know what that is. You'll have to tell us what it is.
Yes. Well, the next page is the well, irrigation well, and the valuation of the structure is 4 lakh, at the bottom side, 4,51,768.
4,51,000.
Yes, ma'am. Present value of structure.
Where are you reading?
No, the page 115. 115, bottom. At the top, valuation certificate, then number 2, name of structure, irrigation well, and 10. Present value of structure 4,51,768.
Is that even though your land is irrigated,
yes,
yet it has been treated as unirrigated.
Yes.
That's
yes. Because the High Court assumes that crop pattern says so. But in one hand, it says that it was irrigated.
What is the extent of land acquired?
1.86. 1.86
Hectare.
Hectare, yes.
Show notice.
There is delay of 70 days. Obliged.
Returnable on 9th February.
May it be the Lord. My lord, the issue here is that, my lord, the issue arises out of payment of surcharge of 12 paise, where I succeeded in appeal before the electricity regulatory, before APTEL, although I had lost before the State Electricity Regulatory Commission. Now, my lord, the legal position, as your lordship 7 fact said, is that interest, that is late payment surcharge, is an automatic and a necessary concomitant of late payment.
But you made a separate prayer for those two, and once those are not considered, implied rejection.
My lord, the prayer, the order finally is appeal allowed. It does not say appeal allowed only in terms of.
Look at your.
Yes, my lord, let us see page 13, my lord.
Page 21 is your prayer.
Yes, my lord, page 21 is the prayer, correct. Absolutely. So let me place the prayers first and then I'll show what was said. Your lordship will see, my lord, prayer A, page 20 if your lordship sees.
Yes.
My lord, A and B are 12 paise which I've got, so no problem. C, my lord, is the late payment surcharge 1.25%. Let's pause here, my lord. Now please come back to, my lord, page 13.
30.
13. Because your lordships are reading the clarification order, I am coming to the original appellate order.
Very. 13.
Yes. Now, my lord, please come to para 16 at the top. The
but para 17 indicates what you are to get.
Yes, the previous outstanding dues. It does not say that I will only get the surcharge.
It only speaks of the 12 paise per unit.
Not over and above the generation tariff determined in respect of PPS for each of the generating units, and therefore direct UPCL to make the payment.
That is all. There is no mention either of LPS.
Yes.
LPS is not there, interest is.
So therefore I am saying, my lord, the last line.
As the APTEL says, you ought to have asked for a review of that order.
No, but,
or you ought to have come
now this
within time.
No, my lord, time I can explain. There's no delay.
There's no question of saying that you will start counting after the
I'll tell you
clarification petition.
No, I'm not saying count it from the date of rejection of my clarification at all. I'm saying please count it from a date on which, my lord, the UP, the Uttarakhand Power Corporation says that I will not give you LPS. From that date we can count it, my lord.
No, you already prayed for this and there's an implied rejection.
My lord, your lordship makes
that is what the APTEL says.
That is what the clarificatory order says. Yes. What your lordships have held, my lord, may I just show one para of one judgment? There is that LPS is a natural, necessary concomitant of.
Then you need not have even asked for it.
My lord, that
If you ask for it and the order is silent, then it amounts to.
Lord, if it says appeal allowed in my respectful submission, it should come. Just have a look at one.
If they left it as that, then it would have been all right.
I understand.
There's a para 7.
I'll just read one line of one para. If your lordships are convinced, well and good. Otherwise, Lord, please come to just give the judgment to them. Lord, please come to para 16.1 straight away. I'm not showing anything of this judgment.
Late payment surcharge also, we have any number of cases. I think I've dealt with 3 or 4.
Yes.
Sitting with various judges.
Yes.
LPS also is put an issue. It is not as if it flows automatically.
I'm just trying to show something from here if it appeals to us. You know, just see para 16.1, which is at around. And in fact, I'm only reading the last line of it because the first part, force majeure, we are not really concerned with. Further, if your lordship will just see further, further he is also argued that APTEL was not justified in granting late payment surcharge to the respondent as the same was not pleaded before KIRC or an appeal. Right? Now, Lord, please come to para 42, which is the last part. Then, this is what it says. Lastly, we also reject the appellant's contention that APTEL's direction to pay late payment surcharge to respondents is unjustified as the same was not pleaded, as we've already held.
But the point of distinction, Mr. Bhatnagar, is that it was not prayed for there. It was not pleaded, not prayed for there.
Pleaded is, in fact, I'm a little better than that.
You pleaded it.
No, I'm a little better than not.
No, you prayed for it.
I'm only relying on this line.
Dug your own grave. Otherwise, you could have been covered by
the direction to pay is explicitly rooted in the PPA. That's exactly the case here. It says shall be paid.
Prayer.
Very well. My prayer is there, but your lordship saying in this case there was no prayer. I'm sorry, madam.
Challenge to the order dated 29/8/2024 would be barred by limitation under Section 125 of the Electricity Act 2003 in the light of the later clarificatory order dated 24/6/2025. We find no grounds to interfere even on merits. We condone the late petition and in consequence the appeal are accordingly dismissed.
Please.
State learned signal just
my lord, because the first come first service is
interim order. We are not going to.
My lord, because the
in any event there was delay on your part in
High Court, the right approved to the person who the decision of the state by arbitrary, my lord.
The allocation was on 22nd September.
My lord.
And you go to the High Court on 10th October. The High Court says that we find no grounds made out for ex parte.
My lord, no. High Court not said. My court.
No interim relief. What else did it say? Adjourn the matter, so you fight.
My lord, what High Court said that there is no.
Now 1172 successful allotments are there who are not even in the picture.
My lord,
no question of.
Bear me 2 minutes only. My lord, the High Court saying there is no systematic error, but their internal audit reports itself says there is an error.
So you make out a case before the High Court. And
High
not
Court,
a case
lord,
for interim.
Because the date is
not a case for interim relief. Sorry.
My lord, because
we find no good ground and reason to interfere.
My lord,
impugned interim order.
My lord, itself
passed by the Delhi High Court. On especially petitions accordingly dismissed. Yes.
No, here I am a bona fide businessman, my lord. Just few brief facts, man. I am actually in the manufacturing of wheat flour.
Look at your prayer.
Yes, for defreezing of my.
The freezing of the account is done by the cybercrime cell. You want a direction to the State Bank to defreeze the account.
Kindly appreciate, man. This is the case. Just kindly appreciate, man. I have got no.
We can't issue that order at all. As if this SBI has some independent discretion to defreeze when it's been asked by the cybercrime cell to freeze the account.
Submit, my lords. We have got no notice from any agency.
You are also not disclosing everything because you say that complaints in different states and union territories also must be clubbed.
Just allow me to, my lord. Just can I? Facts are facts.
Something more than meets the eye.
Just say something, my lord. I got no notice from any police. No back.
Some amounts are coming into your account which are part of some cybercrime.
Show at page E very specifically. I don't know how this is. Can I just submit, my lord? I am a bona fide.
Not a case for clubbing or for granting or for defreezing.
No, okay. Sorry, just allow me to at least give the fact. This is a key. Just give me a moment.
Not a case, Mr. Kaushik.
Just give me one.
They condone, however,
just
one
moment. I am a bona fide.
Not a case.
From which this payment is some.
There are some things which you are not disclosing. Going by your prayer itself, it is clear that you are aware of some other complaints in different states which you are not disclosing.
Can I just say, unofficially, unofficially, the
Will I
people told that there are.
However, we find no grounds made out to entertain this writ petition filed under Article 32 of the Constitution. Writ petition.
We actually don't know from where this payment,
Dismissal of this writ petition shall not preclude the petitioner from availing appropriate remedies. So from invoking appropriate remedies available to it in accordance with law before the appropriate.
Very well, man. Great.
Adjournment is sought by the learned counsel for the petitioner on the ground of ill health list on.
My lords, interim relief granting exemption from surrender.
That exemption is already granted.
My lords.
When?
My lords, 10th of November.
List on 9th March. Exemption from surrendering granted on 10th November 2025 shall stand extended to the next year.
Item
number 26.
Lordship, we are being led by Mr. Dave. He's on his legs in court 3. I'm requesting pass on.
Mr. Dave is appearing.
Yes.
You want a pass on?
Pass on. I'm grateful.
Number 27 along with 61.
Wait, please, sir.
Yes.
But here is a case, my lord, your lordship says there is absolutely no allegation.
You are members of the tender committee.
My lord, tender committee, and what have I done? I am just a.
We don't know. That is exactly the point. That is why it requires to be looked into.
Me to just read what is there
Not
in
a
the charge
case
sheet.
for quashing, though.
No.
How is it a case for quashing when you are a member of the tender committee and the tender committee is alleged to have committed irregularities?
Milord, there is no irregularities shown.
What is what requires to be tried and tested?
Your lordship will see the evidence of PW11 that has been on the basis of which the charge. Please just read that, Milord.
Which page?
Milord, if your lordship comes to page 48.
Yes.
PW11, Milord.
Yes.
Their document before this thing, Milord.
This is his 161 statement.
Yes, Milord, statement he is an officer who has been examined, Milord, of the department before the filing of the charge. Your lordship may just come to it. Page 48, Milord. Page 48.
Yes.
What are you? I'm sorry, Milord. Milord, today I have produced the general rules of registration of agencies with NPCC, the guidelines of NPC Limited and other documents to you. On being asked, I further state that previously NPCC was doing the works departmentally as it had its own machinery and equipments. But subsequently from 1985 onwards, NPCC started suffering losses due to excessive manpower and less work in the hand, resulting in less turnover and financial crunch.
How does this help?
Therefore, NPCC started procuring works following pre and post tender tie-up. This is the case of a pre-tender tie-up.
Very well.
12 people were, Milord, this thing. That is all that the tender notice was. Milord, the charge sheet also shows, Milord, they're making out a case under 13.1D, Milord. How there has to be some allegation of some.
Not a case for quashing.
No, not quashing. My discharge application has been dismissed.
That is one prayer. You also asked for quashing, both.
There are two, Milord. My discharge.
Your discharge was dismissed. Obviously, you were part of the tender committee. Where is the question of discharging you now?
There is no, Milord, 13.1 is not made out at all.
Not the case for letting you walk at this.
Judgment has held, Milord.
Sorry, counsel. Next matter.
Then your lordship permit me to withdraw it then, Milord.
Having argued for some time, then senior counsel for the petition.
And same ordinance 61, Milord.
Both.
Please.
Dismissed as withdrawn.
Well, this matter arises after the rejection of the criminal revision.
When it comes.
This arises out of the rejection of the criminal revision, lordships. The core issue involved. The core issue.
PW2. You saw the
PW2 is the eyewitness who named
Millets,
you.
this is what they were saying, that this is the eyewitness. However, they are relying, as per the High Court's order as well, para 8, they were saying.
That's sufficient to at least summon you. Where is the question of you saying I?
No, Millets, there
ought
are
to have been
three
summoned?
reasons, Millets. Number one, that the post-mortem report says, what he says that I've been dragged, I've been beaten by the sticks, lathis, but the PM report says that there is just a ligature mark, nothing else, Millets. And the independent witnesses have been done, Millets, by the investigating officer, and I'm not just the only one, Millets.
Find no good ground and reason to interfere with the impugned judgment.
Millets, there were 5 more persons.
Especially petitions according to this. So far as you are concerned, PW2 statement is sufficient.
Let's at least next record may kindly recall.
No. Adjournment is sought by the learned counsel for the file the document in terms of the earlier order dated. B document also. File document in proof of the petitioner being a deserted wife as on the date of allotment of the plot, in terms of the earlier order dated 22/9/2025. List on February 9th.
May it please your Lord.
Yes.
But in this case, even though they have been appearing on caveat, but no notice has so far
Notice has not been issued.
So the vires of the 2 rules are under challenge.
More than 10 years now, your client is still interested.
He is, Lord, what is happening?
He was terminated in
2014. What is happening is, Lord, there is a High Court judgment taking a view on the rule, but your Lordships have not examined it. It's a matter which arises repeatedly. So therefore, I can address your Lordships, Lord, either on the rule. So there are 2 points of argument. One is of discrimination and other is of protection under Article 311(2)(b). So if your Lordship will see the rule, I can take your Lordships to the rule and make the submissions. Or your Lordship can take it up on a non-miscellaneous day or something. I'm going to take a little time.
For issuance of notice?
No. Not issue. If it's just going to be argued. My friend has been appearing on more than one occasion. If they don't want to file, the vires of the rules is in challenge.
There is no notice. There is no question. Now, may you show that the submitter...
Let Mr. Patwalia finish thereafter.
Correct. So kindly see the rule. At page 17 are the rules.
17.
Now, the High Court takes a view that, let me just make the point.
Yes.
High Court takes a view that because I have 40 officers assisting me, development officers, so therefore I am in a position to meet the targets. Now, on that, there is a serious dispute. Please have the High Court finding on that issue at page 56. Please see page 56. Then I'll show the rules. But the problem here.
Yes.
Page 58, sorry. The bold type page 58. Para 50. As to the agents, it has been submitted. They form a distinct class. They are not employees of the corporation. They work solely on terms of payment of commission. No parity may be drawn with them. Suffice to note, not less than 40 agents are assigned to any one development officer at any given point of time. Without getting into how many new policies an agent may procure for the corporation, it is submitted there is no arbitrariness, inherent arbitrariness on the part of the corporation in subjecting the development officers to the rigors of Rule 3 read with 6, 8 and 7. Now on this, Lord, kindly have first P3 my appointment letter, which says that how many development officers you are supposed to have at page 159, 160. Because ultimately they say your cost ratio is not effective. My case is you don't provide me with the manpower. Now kindly have page 159, clause 10. During the probationary period, you shall secure through the agents recruited at your instance minimum completed life business of rupees so and so, yielding a scheduled year first premium income of not less than rupees 10 lakh, provided in case the pay and allowances admissible to you under clause 1 are increased, minimum business and premium which should also increase proportionately. Please turn over the page, serial number 3I. You will be required to recruit minimum of 40 agents, out of which 40 should become active. 30 agents should individually have put in during that period the minimum business required of them in one agency according to Rule 9 of the LIC agent rules, 1952 and 15 agent, etc. So the whole scheme is I'm a development officer. I have to recruit 40 agents. Those agents will provide business, and therefore I will be able to meet those targets. I'll show to your lordships. Now, the procedure of recruiting an agent is I recommend an agent to the branch manager. The branch manager then screens the agent. After screening, he is sent for training to the training center of the LIC. Then the agent has to pass an IRDA exam. After he passes the exam, he gets a license. After he gets a license, the agent recommended to me may come to me, may not come to me. So when I get a termination notice, please come to page 234. What is my reply to that termination notice? 234. My reply, para 2. Because not this, what is happening, this is only 2 people. But let me tell your lordships, this litigation is being supported by a large number of development agents because this kind of insecurity is haunting them all. So therefore, this is a much larger issue where your lordship would need to look at it. Now, please see page 234, para 2. Now, this is my response to my termination notice under Rule 7. As per job responsibilities mentioned in the appointment letter given to me by the corporation, I have to grow and develop the insurance business in the area allotted to me through the agents kept under my supervision by the corporation. But the actual fact is, till date, no agent has been allotted to me by the corporation. Due to this, my insurance business did not grow.
So you appointed them, they did not come.
No, I recommended people. So the problem is, I can't appoint. I recommend to the branch manager. The branch manager screens. Then he has to be sent for a training to the LIC college. Then when he comes back, after the training, he takes an IRDA exam. After the exam, then he gets a license. After he gets a license and he's ready, he goes back to the branch manager. So my recommendee may not come back to me. So
you didn't get anyone at all?
No, I have said so in black and white. Till date, no agent has been allotted to me. Please see page 235 and just see the top of my reply. And their rejections are all 2-line, 3-line rejections. And it's a very heavily loaded kind of rule against these development agents. And the problem is the insecurity. Now, they have a rule 15 which says, if we throw you out after 7 years, we will give you a class 3 appointment. Now, a development agent is a class 2 appointment. Class 1, there is full security. You do business, you don't do business. Once you are appointed, you are confirmed, you continue. Class 3 and 4, there is full security. Only class 2, us, we are completely at their mercy. After 10, 12, 14 years, they are thrown out because you don't meet the target. They have families, they have children. People just don't know what to do, where to go. This man, my lord, he has done some LLB and he's trying to make his ends meet without much success. In some court, he's running around now, the gentleman who is there. And so therefore, my lord, just kindly see para 3 also. The job responsibilities mentioned in the appointment letter given to me, I motivated and encouraged many people to become agents of the corporation with my full dedication and commitment for recruitment of new agents in my allotted area. But due to the complexity of the agent recruitment process, high examination fee, people did not take interest in the work, as a result of which the expected mathematical results were not achieved. I was not provided any assistance by the corporation at any stage of this entire process.
So this indicates that your recommendees left there.
Some of them, they have to take exam. It's a long drawn process. They have to relook at it again, Lord. Now what happens now? Another practical problem, I can file a detailed affidavit on this also. Another practical problem is, once they are trained, then they can have their own agency also. So why should they give money to me? So we recommend they get trained, they take the exam, they become a licensee, and then they give us, they say, thank you very much. Now we are going. So therefore, as a result of this, more and more people are not able to meet targets. There is huge insecurity. Maximum business is brought by us. Now, please see the arguments. And the High Court presumes that, I've read page 50. Please see my grounds of appeal. My first appeal is that this presumption is wrong on which the whole judgment is based. Please have page 92. Clause para C. My very first appeal. Ground.
92.
Yes, because the High Court misinterpreted and was incorrectly led to assume that any development officer at any given point of time is assigned a minimum of 40 agents by respondent number 1. In the following paras of the judgment, High Court has stated that it is responsibility of respondent number 1 to ensure at least 40 agents are assigned under any development officer at any given point of time. I don't need to read the paras of the High Court judgment, my lord. Kindly come to page 95.
Yeah.
Because it is incorrect to assume that it is the responsibility of respondent number 1 to ensure minimum of 40 agents under a development officer at any given point of time. According to the rules and policy, it is responsibility of development officers who suggest agents can only recommend and suggest an agent for appointment to respondent number 1, after which respondent number 1 confirms their appointment. Person must fulfill the conditions prescribed under the LIC rules read with insurance regulatory agent so-and-so. Once they are able to fulfill these requirements, agents are assigned to the recommending development officers by respondent number 1.
They should have come back to you then.
But they don't. My reply P11 says not a single person came to me. Now,
so all the persons you recommended, all of them left.
They also allot. They allot to people. So it's
other than the
yes. It's not necessary that if I have recommended or suggested somebody.
Very well. At least a reply is required to meet all these aspects.
And the other thing, Lord, kindly see on discrimination also.
We'll issue notice.
Can I just, Lord?
Unless you have something to answer all these issues, right?
Yes, Lord, in seriatim, Lord, the first submission addressed before your Lordship was, this is not an issue that your Lordship should notice.
There is no caveat required, Lord. I mean, for issue, it's
all right. I didn't interrupt my learned senior colleague, he shouldn't interrupt me as well. Please see, my Lord, 3 occasions. Patna High Court Division Bench, full bench of the Kerala High Court, Karnataka High Court Division Bench, looked at, Lord, this very challenge. Repelled it.
Same rules.
Same rules. Can I just show last in sequence, my Lord? Just take this compilation, my Lord. And my Lord, this rule has been brought in on the recommendation of the Union of India, my Lord. It is not otherwise brought in because there's a committee, my Lord, appointed by the Union. My Lord, development officers, can I just preface, my Lord, what I'm going to show before, my Lord, your Lordship see this? There is, my Lord, a committee appointed by the Union of India to look at, my Lord, this class of employees called development officers.
Let him file all this, my Lord.
Can I just, my Lord, just take 5 minutes, my Lord? My learned friend had a uninterrupted, my Lord, say.
But at least it requires
Can I just show that your Lordships have rejected this challenge? Please see, my Lord.
This court has rejected it.
Yes, my Lord. The Vairy's challenge to this rule, 6.8, has been repelled by your Lordships, my Lord.
Where is that?
Can I just see,
the same rule?
Same rule, my Lord.
Same rule which is
yes. Please see, my Lord. Judgment of the High Court, my Lord, of Kerala, full bench, my Lord, a division bench. Please,
show us the judgment of this court.
Yes, Lord. I just want to show one finding and that affirmed by this court. Please see, my Lord. Sonia Bhaskar, the judgment starts at page 72, my Lord, serial number 3.
Yes.
And please see paragraph 2 at page 72, my Lord.
Yes.
Lordships at page 72, my Lord?
Yes.
LIC versus Sonia Bhaskar, please see para 2. Learned single judge, by the impugned judgments in both the set of writ appeals, has set aside the termination orders of the petitioners. However, prayer of the writ petitioners to strike down, please mark, not the same rule. Rule 6.8 and 7.1 of the LIC Development Officers Rules 2009 was rejected. Aggrieved by the said judgments, so and so. Now, please have, my Lord, the finding at page 79, my Lord, issue number 1.
Sorry. Yes.
The High Court goes into this threadbare, my Lord. Issue number 1 relates to the validity of Rule 6.8 and 7.1 of the 2009 rules. Petitioners have submitted that the above rules are arbitrary. Unbridled power has been given to the zonal manager to terminate the services of a development officer. It is submitted that the service under the rules is arbitrary and unguided exercise of power. It is submitted there is no valid reason for subjecting only development officers with termination under the rules. No such cost ratio or expense limit is imposed.
No, these are all the arguments.
Right. Now, please see, my Lord, the finding at page 88, my Lord. Exactly the same challenge that is being raised today.
Oh, no.
Please see page 88, my Lord. Please see para 47 at 88, my Lord. From the grounds, as has been noticed by the Apex Court, it is clear that rules 6.8 and 7.1 of the 2009 rules cannot be held to be in excess of the rule-making power of the government, nor can it be said that
it is the judgment of the Apex Court that they're referring to there.
Yes, Lord. That is not quoted at para 46, my Lord.
Why don't you show us that judgment?
Yes, my Lord. I'll straight away come to that judgment. Lord, there, what is? Please see para 45. This is in another context, my Lord, not that rule.
Yes.
Para 45 is referring to, my Lord, the judgment in Indian Express versus Union of India and Higher Secondary Education versus Paritosh book.
You are saying that this court has already considered
an argument
was that judgment.
Yes. Now, not this. My Lord, can I just place 47 and 48? This has been affirmed by your Lordships, is what I'm saying, my Lord. See, please.
By a simple dismissal order.
Correct. Can I just show 47?
Is that a simple dismissal order? Is there a consideration?
Yes, please see, my Lord, at 100.
That's a Madras High Court.
Yes, Lord. Please see, my lord.
File your reply, please.
My lord, can I just
show notice?
If your lordships will only permit me to show.
Council, file your reply.
Very well.
You're on caveat for R1 alone.
For R1, my lord.
LIC.
For LIC. Lord, and just one last submission, my lord. This whole argument.
Require a reply. Please file your reply.
40 agents, my lord, is not the challenge, my lord. We are challenging, we are considering the Virey's challenge, my lord, not that 40 agents were not allotted to him. That is not the focus of the determination by the High Court.
Based on counter usual order after that. We'll take it up on a non-miscellaneous.
Grateful. And only one thing I want to say.
20th January.
When my friend's colleague gives judgments to the other side, they are handed over. They are not thrown at the other party. I take very serious objection.
Oh, sorry, we didn't see that.
She just, from there, she just threw it like that. I'm sorry.
There was a distance, my lord. I just wanted.
You could have walked over and handed it.
Yes.
I walked over.
And
It's okay, I don't want to, my lord, join in here.
No, my lords, this is not what happened. I walked over. My learned friend is not being said. I walked over. There was. I walked over. I put it on his table.
Anyway, I just wanted to say that.
It's unfortunate that this kind of argument is being raised. Not let's focus on the merit.
You must also instill
this kind
some sense of courtesy in.
But this kind of shadow boxing should be avoided.
There is no shadow boxing here.
Not just taking my learned friend, what he said on face.
Well, they are also saying that you threw it.
His briefing counsel is saying that.
There are people sitting
Well,
here.
the audience also says so. Madam, you please be mindful of your conduct. That's all.
Grateful.
We don't know because I was not looking
Yes,
at what was happening.
I would not have said it.
But there are people who are sitting at the back who say that you threw it. So
Lord, there is no occasion to throw anything, my lord. We are assisting the court, my lord. We are not joining issue with the other side, throwing things at them.
A lot of counsel
Unfortunately, this kind of an allegation is being.
A lot of counsel seem to think that when the other side is arguing, you must also make faces. We have seen that happening. So
very well.
Do not identify with your client.
Exactly.
To such an
Nobody
extent
does. That's not the issue.
that you step into their
kind of an argument, my lord, is
no, even worse.
Let's focus on the merits of the matter, my lord.
Anyway,
humble.
File your reply.
Great. There's a letter in 31.
No letter.
Then, my lords, I'm still seeking an adjournment, my lords. There's bereavement in Eva's family. I'm seeking adjournment for 2 weeks.
You're for the respondent. A report was called for.
Report was
Yes,
called for. It's not been submitted.
Why the application has not been disposed
Yes,
of till
Lord,
now?
regarding the pendency of 28A application.
Why has it not? It's still not been.
We have not got instruction, my lord. I'm taking 2 weeks to file my.
This is practically in the nature of a contempt case because it's a miscellaneous application, no doubt. But if you're violating an order of this court, then
My lord, there's a bereavement, my lord. I'm taking 2 weeks.
1 week.
1 week, your lord.
Adjournment is sought on the ground of bereavement in the family of the learned counsel for the respondents. List on.
Which may give a fixed date.
First decide.
Number 32.
Adjournment is sought by the learned counsel for the petitioner. Still awaiting.
Yes, your lordship.
When was the judgment reserved?
I think I have to.
You don't know when it was. Adjournment is sought by the learned counsel for the petitioner on the ground that the judgment is still awaited. Judgment in the connected matter is still awaited. List on second page.
Match the list. Number 33.
Two SLPs have been dismissed, but that dismissal favors me. There is one point. Because in the reference code, concurrently, I have not been paid on the trees under section 3. In those matters, reference code had awarded the separate compensation on trees and civil structures, which is ultimately confirmed by this honorable court. So, kindly see by the. But I'll just read out.
You've just been denied the interest and the benefits.
Luckily, I have annexed those judgments before this honorable court in this matter. And it's page 94.
94.
P7 at page 94. And I'll just show the table mirrors in which the reference code allows it. Page 94, annexure P7.
Yes.
Very first appeal.
How do you explain the delay, Mr. Khan?
Delay.
4 days in my SLP.
No, not the 54 days.
Yes, delay also I have a point. I understand.
Court order says was passed on 2nd of January 14.
I understand.
Then
just show two dates. I can justify on that.
You have filed an appeal
Yes,
in
yes, my lord.
2024.
No, my lord.
Yeah.
That registration date is wrong. There was 2 years delay, not 10 years delay. I will just explain it. May I justify on
your
the
appeal
date?
is of 2024.
I have annexed the appeal memo. I can show from the appeal memo.
When was it filed according to you?
Just a moment. First appeal was filed on 11th of August 2016. I can show from annexure P5, page 67. That is the appeal memo.
Page 67.
Page 67, Jagdish Chandra. Annexure P5, page 67. Bottom of the page, notes, appeal memo, page 74. Kindly see. It was filed on 11th of August 2016.
How is it possible?
That's what happens, even in my experience from Bombay High Court, notes, due to paucity of funds, they can't pay the court fee. So unless that court fee is paid, the matter is not registered.
Then it's just kept pending.
It lies in defect, notes.
For years together.
Notes, even we have worked in the reference court, most of the farmers are unable to pay the court.
Practically, it amounts to filing in
It remains
2024 only
It
then.
remains in defect. So there was no substantial delay. 1 point.
Well, where is
Now on
it?
page
You can't
7,
say that it will date back to 2016.
I understand.
Effectively, you filed it only in.
whatever happened, I have explained it to my lords.
No, but once that delay is there,
But
obviously
my-
the interest would not
The
be payable. for
ancillary
that.
point in which the other SLPs are dismissed, in which the
Sorry, Council. Delay
in other SLPs,
However, we find no good ground and reason.
in other matters, the reference court awarded the compensation on trees. Lords. So there is no delay of 10 years. I leave it to you, lords.
You are granted compensation for the trees, is it not?
No,
Only
lords,
interest
that's
is not paid.
concurrently it is not paid, my lords.
Now, interest and statutory benefits for that period is not paid. Not that you're not
No, my lords.
paid
Trees
the compensation.
concurrently, even in reference code, I'll show the reference code judgment.
Now, are you not paid compensation? You
Compensation
are
of land is paid, my lords.
even for the
compensation
trees you are paid. It is only the
But same
interest
survey-
and the statutory
same
benefits for
adjacent
that
survey
10-year period that you are denied.
Last submission. Same set of evidence, adjacent lands, other landowners have been paid the trees, my lords.
Well, they came in time, that's why they get interest and statutory
My lords, in
benefits
reference
also.
code, I
You
am
don't
saying
get that.
My lords, I am saying that even before reference code, I leave it to you, lords. Oblige, lords. Grateful.
Number 34.
My lord, in item 34, I appear for the complainant informant R2, my lord. We had filed our Vakalatnama last Friday on 21st, my lord. I only see 2 weeks time to file our.
State also.
My lords, we have filed on counter.
Counter.
My lords, interim may please be continued.
Learned Council appearing for respond number 2. You entered appearance already?
Please, my lord. The Vakalat has also been filed, my lord, on the 21st.
I see.
Grateful, my lord.
States that I seek stand to file the counter after. You should not have to that. Interim order dated 22/9/2025. Shall continue to operate till the next year. List on 12th, 16th.
Grateful.
Grateful, my lord.
16th January.
Number 35.
I'm also on behalf of.
You are appearing for the state of Himachal Pradesh.
My lords, 3 weeks to file the counter.
You have not entered appearance
No,
also.
my lords.
Very good. Learned Council. What is your name?
Indradeep.
Indradeep Kaur. Ms. Indradeep Kaur, Learned Council states that she is instructed to appear for the state of Himachal Pradesh. Full stop. She seeks time to enter appearance and file a counter. Usual order. Exemption from surrendering granted earlier shall continue to operate till the next hearing. List on 13th February.
Item number 36.
Item 36, my lords, I beg to appear for the petitioner. My lords, in the last petition.
Comprehensive LR application.
Yes, so my lords, the problem now we are facing is that out of 5, we have found out there 5 again. 3, I have already filed an application. 2, one is the sister, one is the other brother. Now that brother has passed away. He has 5 children, what we have got to know, but they're all married. So we are finding out the whereabouts.
One more time.
And we'll require more time because.
Further time is sought to file a comprehensive application for bringing on record the legal representatives of deceased petitioner number 1 based on 13th February.
Item number 37.
My lords, this is the SLP by which the respondents have refused to refund the additional FSI, my lords, that we had paid. It's that matter.
This requires a hearing. Counter is filed.
It's fine.
You need to file a rejoinder too.
No, that's,
So we'll take it up on a non-miscellaneous.
it's a short matter.
Today, of course, it's difficult. We in fact have a final hearing fixed for today, which obviously will not go on.
Your Lordship will not, in that case, may have it tomorrow.
Tomorrow you'll only join the queue. It will not come up.
Put it up on Monday. It's a very short issue.
We don't know when the next available Monday or Fridays. Next available Monday or Friday.
First December.
Then?
December already.
No, tell us which date is available next.
First, second, 11th, 5th, 9th, and 8th.
Available date?
Hearing that.
No. Give us a date on which there is no hearing matter already fixed. That is a miscellaneous day, either a Monday or a Friday.
12th.
12th? 12th of December. 12th December. But it's on 12th December. We'll take it up at 2 p.m. or after the end of the miscellaneous matters, with the understanding of matter. 38.
In this case, the dispute is between brothers.
Yes.
There was a compromise order, and on the basis of that order, checks were carved out. Subsequently, that order was set aside. That necessity.
No one is appearing though.
Nobody is appearing on it in this case. Lordship, you see the order which was challenged on page 39, one line order.
Yes.
Although this order 393979 was already set aside, but the reference was accepted on the basis of this very order.
79 order.
This order was already set aside.
That was set aside. And this later order. Granted, the judgment and order dated 24/3/2023 as per the High Court of Judicature at Allahabad in writ B number 9012 of 1981 and the judgment and order dated 28/4/2023 in civil miscellaneous review application number 187 of 2023 in writ B number 9012 of 1981 are under challenge in these appeals. Despite service of notice, which respondent is?
Respondent.
None of them came in there.
Nobody
in the state.
Service is complete office report.
On all the respondents, despite service of notice, none of the respondents have chosen to come before this court. Have chosen to enter appearance before this court. Status quo orders were passed as long back as on 18/8/2023, and who is the private respondent here?
4 to 9 months.
And respondents 4 to 9, the private parties affected thereby would be well aware of the same. Their indifference to this matter would necessarily have consequences, and they are accordingly set ex parte. The High Court perusal of the interim orders reflects that the High Court failed to take note of the fact that this fresh reference number was order dated 4/11/19. Where is, which page is that? 4/11/19, 31. 31. Reflects that the earlier order dated 3/9/1979 passed by the consolidation officer.
Was set aside.
Consolidation officer where? What order is there? 3/9.
25 page, 25 minutes.
Page 20. Mirzapur
This was set aside by result.
was set at naught by the later order dated 4/11/1980. Passed by the Settlement Officer of Consolidation, Mirzapur. So,
He said to say by the DDC.
No, set aside by Deputy Director on page 30, madam.
page 30, is it?
Yes, madam.
I thought the 4/11/19.
Yeah, that is the second reference.
Second.
That has not been
Second
considered.
not by the Joint
Director
of Consolidation,
Allahabad.
Allahabad, with a order dated 21/6/1980. In the light thereof, the Joint Director could not have placed reliance on the order dated 3/9/1979 or accepted the same as was done by him with the order dated 9/4/1981.
39.
Which page is that?
39.
Page 39.
39. The Joint Director also mentioned the place. Joint Director of Consolidation, Varanasi, Cantonment, Mirzapur. This aspect of the matter was lost sight of by the High Court. In the appeal is accordingly allowed, setting aside the order dated 9/4/1981, passed by the Joint Director of Consolidation, Varanasi, Cantonment, Mirzapur, and restoring the order dated. Now it will have to go back as per this 4/11/1980.
Yes, madam. That has to be decided first.
4/11/1980 is at page 31.
Page 31.
31 starts at 30.
It started at page 31.
What did I say last?
And the appeal is a
But I'll also send it back to the High Court.
481, asked by the Joint Director of Consolidation, Varanasi Cantonment, and restoring the order dated
4/11/1980, passed by the Settlement Officer of Consolidation, Mirzapur. Requiring the parties to be present in the court of the Joint Director of Consolidation. The parties shall approach the Joint Director of Consolidation for fixing an appropriate date to take up the proceedings. You can approach him and ask for.
The status quo order should continue to be.
Status quo order may continue.
The status quo order shall continue to operate till the matter is decided afresh.
Item number 39. Please, my lords. My lords, on item number 39, I beg to appear for the appellant through VC. But this is the second appeal under the IBC. On the last occasion, the other side, they sought time. I believe, my lords, we have been served a copy only on this Friday. I'm not sure whether the same is on record.
The counter is here.
Thanks, the counter is there, ma'am. It's primarily a reiteration of what I have said before the appellate tribunal. So the matter can be taken up today, ma'am.
You
My
need
lords,
some time?
My lords, in that scenario, I'll be needing some time because 13 October indicated that I'll be granted 2 weeks time to file my rejoinder.
Well,
But I'll just need a week's time, my lords, and it may be
very
listed
well.
after a week.
Counsel for the petitioner seeks some time to file the rejoinder, the counter affidavits filed in the main appeal as well as in the IA. List on
Well, 18 December is convenient for my lord. I'll be traveling.
18th is a Thursday. It may not come up on that day.
17th,
12th is all right.
15th, I'm just.
Very good. 15th. 15th is.
My lords, I appear for the respondent number 1 to 4, my lords.
Yes.
In item 40, my lords, I'm seeking 1 week time to file the counter, my lord. I just received in the morning. I had circulated a letter, but how unfortunately that could not.
Counsel for respondents 1 to 4 seek some more time to file a counter affidavit.
Rejoinder thereafter, my lord.
Rejoinder there. Usual order after that. Then 23rd Jan.
Interim orders to continue, my lord.
Earlier interim order. Dated 28/3/2025 shall continue to operate till the next year.
Item number 41.
Pleadings shall now complete, my lords.
Counter and rejoinder
Yes,
both
yes,
filed.
yes, my lord.
Please, my lord. My
Take it up
lord, I
on
am on
Tuesday
behalf
then.
of respondent, my lord, in this matter.
Yes.
My lord, due to some personal difficulty, main arguing counsel is not available to. My lord, 2-3 days ago, we have received the rejoinder.
Response seeking time. GLS will.
My lord, we are on behalf
Shankar
of
Narayan, you are appearing.
Led by Mr. Shankar.
He's appearing. So we'll
Because
take it
I'm
up on
appearing for the
Tuesday.
petitioner in this.
Yes, we'll take it up on a Tuesday then, Mr. Shankar Narayan.
Very well. Very well,
Based
my lords.
on-
Pleadings are complete, so.
Yes.
Please, my lord.
13 then.
Keep your interim may kindly be allowed.
Earlier interim order. Dated 28/3/2025 shall continue to operate till next year.
Well, the item 42 as per last order.
Yes.
I had sought permission to file certain documents which I have.
You filed up.
I'm seeking a password minutes.
Now it's getting a little too late for a password.
Well, it's the council is on his legs.
Lordships can have it next week, short issue, not much. Section 37.
Arbitration award and patent illegality is what the High Court finds.
Yeah. Whether a term could be
They didn't
implied.
ask for an extension is the finding.
But my lordship, that the main point is whether an arbitrator could have implied a term in the contract or not. Settled proposition. That's one short point.
Does it require a lengthy hearing? Then we'll take it up on a
Half an hour.
miscellaneous.
Half an hour. Not a lengthy hearing.
When is the after 12th? When is the next date? Miscellaneous date available? 15th is on. 15 December.
Okay.
Because the service on respondent is not complete. Lords, we tried.
Steps not taken.
No, Lords, what happened was, Lords, because they had my brother.
You not filed spare copies of.
Lords, we were no. That the reason is, Lords, it was to be served on the same address. So we inquired whether they are residing in the same address or not. Since because the earlier office report says that no person such found. So now it is transpired they were evading service. They are residing at the same address. So Dusty service may be ordered. Lords, will get them served within a week.
Dusty service was permitted? No.
No, that was
Dusty service is permitted.
Lords, initially it was done, but at that time we had not taken steps. That was purely artistic. But this time it would be done.
Respondents 1 and 2 still remain unserved, and counsel for the petitioner is committed to effect service of notice afresh upon them, including Dusty.
So great to me.
Item number 44.
The letter was circulated by the respondent seeking time for counter.
44, yes. And counsel when that 16 January. And 44, adjournment is sought by the learned counsel for respondent number 2 and 4 to 6. To enable him to file a counter affidavit. Usual order after that. 9th February. Earlier interim order dated 16/5/2025 should continue to operate.
Insofar as respondent number 1 is concerned, is a contesting respondent. My lords, the whereabouts are not known. That is what the postal remark reflected on the last occasion.
So service is not.
My lord, service couldn't be effected on respondent 1. I haven't been able to procure the address, my lords. May I request for a substituted service, my lords?
You'll have to file an application.
Very well. It's no difficulty.
1 and 3 also.
My lords, 3 has passed away. I'll take steps to get them on record because 4 and 5 seem to be related. I'm so deep.
It won't take time.
45.
May please, my lords, I appear for the petitioners in this.
16.
Pleadings are complete in the first SLP.
Yes. 45. Yes.
Yes, ma'am. There are two petitions. I am appearing in the first one.
Who is the petitioner in the second one?
I beg to appear for the petition.
Who is he though?
And then
Who is he?
he is the father.
Oh, he's the father?
Father of the petition.
Oh, the Muthuras Subbarajan, and
Yes.
their father.
This is a gross abuse. 3 times, they have come up to the Supreme Court. A 300-page document of partition signed by him, and he is the one who sought conciliation of our stepbrother.
There is none.
All that is recorded, and now in a suit.
It's a complete fraud by them to claim there's a conciliation award when there is nothing of the sort.
Mr. Shankar Narayan, it is perhaps better you are here in person then to match the
I'm sorry, would you not pass it over? I'll just come there.
Gross abuse is all I can say.
We'll hear the matter.
Please hear it at the earliest.
Yes.
Since when?
How many settlements the lordships have said?
Well, I adopt all of Mr. Rohatgi's arguments for myself.
That's right. That's how it has happened. Otherwise, it would never have happened.
Now, with great respect,
It happened only because of the
assume. And we argue, we will place what our
Please,
questions are.
my request is at the earliest, both these gentlemen are beyond 75.
We had agreed.
I'm fine with any day.
The Gen series, though there is a partition, they are still sitting on the properties that are allotted to my share. We have indicated they have profited to the extent of 1,000 crores.
Well, there's a receiver in place, no prejudice is being caused.
High Court judge, madam, is in charge of the property. Everything is in the custody of the High Court judge now. He is administering, one retired High Court.
There's no problem is under the table, the High Court judge will not know what is happening.
1,000 crores.
Now you want a non-miscellaneous day, obviously.
If possible, if it's possible, we'll take about 20 minutes.
I would take
We
not
want
more than
to get on the background to show your lordships the grave fraud played by them repeatedly.
To show them miscellaneous day then, Friday.
300-page document says I have signed.
Every page.
Lord at the earliest.
Non-miscellaneous day.
January, look at January and tell this. January.
Grateful.
19th would be a last working day that. January. 9th, first week will be miscellaneous. So first week, entire week will be miscellaneous, no?
That's right.
So after that, 12th, do we have anything? No, 12th January.
Grateful.
The interim order may continue.
Yeah, interim order, stand to the next state of hearing. That usual order. With the understanding it will be taken up after the hearing of all the other matters.
Grateful.
What is it?
Yes, adjournment is sought by the Land Council for respond number 1 to enable him to file a counter affidavit list on 9th March interim order dated 26/2025 shall continue to operate in the next hearing. Now who is asking for? One only. You have not filed your wakalat.
Yes,
Mr. Gopal Jha. Mr. Gopal Jha, Land Council, it's time to enter appearance and file a counter.
Okay.
47.
Yes, Palak, this is a case in which Palak, the three revenue authorities, the assistant collector, the deputy commissioner, the commissioner, all three recorded concurrent finding of fact that respondents 1 to 4 are obstructing.
The notice was ordered in
Yes, sir, all I'm saying is, Palak, the impugned order says, the impugned order, the High Court says the writ petition is dismissed, yet gives certain directions. May I just show your lordship page 2, so small paras of the impugned order.
Page 2.
Page 2, my lord.
Some resolution to be passed or something.
Yeah, but then there is no, just permit me. Page 2,
Has the
paragraph 2.
resolution been passed now?
No, not to my knowledge.
Not you know.
Page 2, paragraph 2.
Yes.
Though this court does not find any infirmity in ingraining the concurrently rendered verdicts of eviction, as they are based on a well-made demarcation and disputed rasta. However, learned counsel was preparing for the petitioner submitted that he has instructions to state that the prayer related with quashing and serving the influence of verdict be permitted to be abandoned. The above prayer is accepted and accordingly.
So you gave up your prayer.
They gave up, my lord. I was the respondent.
You are the respondent.
And the writ petition is dismissed. Then to undo that, my lord, the unauthorized occupation. But the para 6 order, certain direction is
Consider to pass a resolution to the effect that in case the encroachments have not resulted in any obstruction, approval to the said resolution be granted.
Well, this is not even prayed in the writ petition. The Lordship see the prayer clause, there is no such prayer in the writ petition. The writ petition is dismissed and yet leave is being given to them and an interim order is also passed. Lordship see the last line. the said be done most expeditiously till then parties to maintain status quo. So in a dismissed writ petition, a status quo order is also passed.
No, he didn't dismiss it. He said disposed.
Disposed of. No, matter in the para 2, he says it's dismissed. Lordship has seen. And they have withdrawn the writ
No
petition.
infirmity in the order.
Yeah, they have withdrawn the writ petition in any case.
This order on the face of it is inherently
Only thing is on para 6 is my lord, just
there is a question of granting you that relief when he says that.
my lord, just if there is some, if it can be worked out, my lord.
They are free to do whatever they want to. I mean, why should the court direct them to do it?
Para 6 is unsustainable in the light of what he said in para 2, and you gave up your prayer. There is a question of giving you relief once you say you are abandoning your prayer.
But this does not affect that. So just have a look at para 6, my lord.
Status quo. You're an encroacher. You are now protected by virtue of the status quo order.
He still says that if
and he says that the Gram Panchayat will consider whether your encroachment is causing any obstruction. So encroachments without obstruction can be permitted then. Is that the signal that we want to send out to encroachers? That you encroach artfully so that you do not obstruct the road. Therefore you get away with everything.
Respect what the High Court says, if they see if something is.
This one be granted. Challenges to the judgment and order dated 11/2/2025 passed by the High Court of Punjab and Haryana at Chandigarh in CWP number 11234 of 2024. The respondent in the said petition, respond number
124.
124.
Another
said petition. You are perhaps only one petitioner is.
Yeah, that's right.
So respond number 7 in the said petition is the appellant before us. Perusal of the order under challenge respects that the division bench of the High Court, division bench of the High Court recorded in para 2 of the impugned order that it did not find any infirmity in the concurrently rendered verdicts of eviction, as they were based upon a well-made demarcation of the disputed. Further, the division bench also noted that the learned counsel for the writ petitioners stated on instructions that the prayer relating to the quashing and setting aside of the said verdicts was abandoned, should be permitted to be abandoned by them. Having recorded this in paragraph number 2, the division bench surprisingly stated as follows in paragraph number 6. Just extract paragraph 6. The contradiction in paragraph 6 when compared to paragraph 2 is apparent and cannot be sustained. Having found that there was nothing wrong with the impugned verdicts, and in the light of the statement made by the learned counsel for the writ petitioners that they did not even wish to press for the quashing thereof, the division bench ought not to have granted protection to the writ petitioners by way of a direction to maintain status quo till a resolution was passed by the Gram Panchayat without even fixing a time frame. Therefore, the directions and the protection granted in paragraph 6 are accordingly set aside, and the writ petition being CWP number 11234 of 2024 shall stand dismissed.
Great.
We are now in the frustrated times.
Hello, sir. I appear for the state. The counter affidavit has.
The copy?
They have filed it yesterday, Your Lordship.
You received it?
Yes.
You need to file a rejoinder. We are informed that a counter affidavit was filed yesterday, but we do not find the same on record. The registry is directed to verify and put up the same by the next date of hearing. Rejoinder thereto, if any, may also be filed by the said date. List on. You have an interim order?
No interim.
No interim. 12th January.
If Lordships may please this side of the day.
We have just 3 weeks.
Very well.
12th.
49, Your Lordship, I appear for the appellant in the lead matter. As per the office report, Your Lordship, the service is not complete in the connected matters, Your Lordship.
Nice.
There are two connected matters, services incomplete.
Well, in this matter,
Office report dated. Yes.
we are for the appellant in this matter.
Which one?
There are contesting respondents are 1 to 4, my lord. In this
No, but
matter.
once all of them are clubbed together. we'll
Yes.
hear all of them.
Yes. So my learned friend is representing the other parties in the other respondents, and I'm also representing the others because they are in the National Commission. They are all the same.
If you are appearing for the unserved persons, file your wakalat, that will take care of it.
Yes.
Do that.
Yes.
Office report dated 21/11/2025 reflects the details of service and shows that some of the respondents in these cases still remain unserved as on date. Needful in that regard shall be done by the next date of hearing.
My lords, I'm for the respondent 1 to 4.
Yes.
I'm trying some time to file my counter, my lords.
Respondents who are represented by learned counsel are at liberty to file their counter affidavits well before the next date of hearing to enable the learned counsel for the appellants to file their rejoinders thereto. List on 16th February.
Item 3.
50 services awaited.
In the lead matter, it is complete, I believe, Your Lordship.
3 and 4 in the
My lord, may
50.1, 3 and 4 are.
3 and 4 are performer respondent. My lord, may I
You'll have to file an application.
In fact, my lord, respondent number 3 is the petitioner in 50, my lords. My lord,
Well, he is not entering
you
appearance.
can accept notice for him, my lords.
I'm only performer respondent, I do.
What about 4 then?
There's 4, my lord, there are 3 petitioners before the Honorable High Court. 2 have come before this Honorable Court, my lord.
We are not going to delete parties for the mere asking. So you'll need to file an
Yeah,
application because you have to do it at your own risk and peril.
I'll file an
There's
application.
no question.
I'll file a performer.
Office report dated 22/11/2025 reflects that service is not complete in so far as SLPC number 25520 of 2025 is concerned. Steps shall be taken in that regard by the next date of hearing. List on 16 Jan.
My lord, may I make a submission, my lord? The respondent, the main contesting respondent is state, my lord. They have been served in both the cases, my lord. They may be directed to
We
file.
don't know who's appearing.
I believe Mr. Samar Vijay.
One is appearing.
Mr. Samar Vijay Singh has entered a memo of appearance in the second matter, my lord.
Not in the first matter. They filed a memo in the first matter, not in the second matter.
In the second matter.
No one is here today.
My lord, my lord, because my lord, we have moved an application for stay as well, my lord. That may be also considered on the next date, my lord, with the enter appearance, my lord.
Registry is directed to print the name of, don't say publish, print. Print the name of Mr. Samar Vijay Singh, learned counsel, who entered appearance for respondents 1 and 2 in SLPC number 25520 of 2025 in the cost list.
Highly obliged.
Yes.
Lord, in this case, my lord, the notice, Lord, the counter is being filed, my lord. But the subject matter is what is over here, and the counter says something very different, my lord. My lord, we were not made a mandatory party while the High Court petition was filed and an order was obtained, my lord. What they have, they say that we have done all these things, my lord. That is
My lord,
something very
may I
different.
just-
Even, my lord, in
may I
that
just-
proceedings, we were not even called for giving our reply.
This
My lord,
R4
I
and 5 have not come.
I have come, my lord. I have filed.
No, for R4.
R4 and R5 yesterday, but it's not on record. Can
Correct.
be taken on record now.
What is your name?
My name is.
You don't know your name.
My name is Imran, and
You are the counsel.
Mr. Chand Qureshi.
Who is the counsel who is taking notice for them?
Chand Qureshi.
Mr. Chand Qureshi, learned counsel. We are informed that Mr. Chand Qureshi, learned counsel, is entering appearance for respondents 4 and 5, and time is sought to enable him to do so and file his counter affidavit based on the usual order after that. He's joined at 8:20
One aspect I may bring to your lordship's notice, in this case, after the High Court's order, the appellate authority considered the matter and appellate authority considered it appropriate to remand the matter to the.
So the stay issue is gone now.
Yes,
And
and
what you mean?
Lord, what has happened?
We were only concerned with the stay which
My lord,
was
that's
granted.
correct, my lord. But my lord, these orders are becoming precedents now, my lord. At least that we decided, my lord.
What steps
because-
have you taken against the appellate order now?
Lord, the difficulty is that, Lord, appellate
That
order,
appellate order, you need to challenge it, isn't it?
Lord, that matter is being remanded back, Lord, now. Lord, ultimately there is a finding, Lord. See how they are.
What remains in this then? This was only in relation to the stay order then.
I bow down on
If
that.
the appeal itself is disposed of, what is it that you want us
Nothing,
to?
Lord, but it is being disposed of, Lord. But the fact is that we were not given a fair opportunity.
We are only concerned with the stay order.
I bow down. What is
Then what remains? Nothing. Don't say all that also.
I may be permitted
We
to
are
tell
informed that the appeal from which the present specially petitioner arises in the context of the stay order passed therein has now been disposed of.
On 26 July 2025.
Don't say now then, has been disposed of on 26 July
2025.
2025. July itself.
Yes, just 2 days after the filing of this SLP, it got disposed of. So perhaps they could not point it out.
July 2020. In that view of the matter, this specially petition does not survive for consideration on merits and is accordingly closed on that count.
Lord, with liberty to approve for appropriate.
This is only the stay. Why do you need it?
No, I think for this.
This is the West Bengal matter. 26. Your lordship had directed that the tainted list be issued, the untainted, we've all taken the exam. The list has been announced. Now, what is before my lords is on the 26th, you have 39 related matters which pertain to what are the next steps, but also pertain to this issue of can the government give 10 marks, up to 10 marks for prior teaching experience? So your lordship will be seized of all of this on the 26th. There are 39 matters.
That's the new regulation.
Yes, my lord, that's
Why would it come before us directly?
my lords. The question is, it is listed before your lordships, and the Supreme Court had earlier heard this challenge and had upheld a division bench's order of the High Court, which said that this is within the purview of the legislature and the executive to have such rules. So all those questions will be before my lords.
When is it coming up?
26.
One of
Item 19. Item 19.
One of the matters.
39 cases.
One of the matters that the unsuccessful candidates and the fresher in 2025, they also challenged that the division bench judgment, and your lordships have dismissed it in that case.
Yes.
We have the order.
There's one matter of concern.
Let's take this up on 26.
Yes, clarification, because today evening the results are to be announced for class 9 and 10. Lordships may clarify that the results should be announced and the selection process is not going to be disturbed.
No.
Yes.
They are not
Explain to your lordships in-
Why do you anticipate that?
What is happening? I tell you, Lord, I have got the
High Court.
Lord, Calcutta High Court
has passed an order.
Calcutta High Court, a single judge has seized herself of this matter and is hearing all these issues, including issues which your lordships have heard in the past.
No,
I
this is not
appeared there,
correct.
we told her that.
This is not correct. Calcutta High Court is hearing the constitutional validity of it.
Anything about
Let the Calcutta High Court proceed on its own way.
Calcutta High Court now seized of 76 matters.
Yes. Your lordships, yours the entire
And
list.
in one matter, certain directions have been given. Of course, we are coming on. Not just according to us, just opposite to your lordship's main judge.
In fact,
interfering.
Anyhow, bring those cases before.
We have moved them.
We need not say anything at this point.
Yeah, but I have
not said anything earlier. Nothing to be clarified.
Nothing to be clarified.
One request, Lord. Just one request. Lord, until your lordships decide this point of this teaching experience legality, on this point, Lord, kindly pass an order, Lord, this High Court should not entertain.
No. Why should?
We are not going to say anything at this point of time.
I am supporting my friend, Lord.
We all
are
support
for some
it.
No, Lord, I oppose.
who are not in the list of tainted candidates. Now, they started a proceeding earlier to somehow expand that list and bring in more people. That proceeding got rejected. SLPs came and your lordship rejected that SLP, your lordship remembers. Now some other people have started a similar new proceeding, again to expand the list. Now the learned single judge is again now entertaining that and taking it ahead.
The issue is completely different.
Now the problem is, we have taken the examination. Now, it has been
This is
kept.
a mess of your own
It
making.
has been kept.
Yes, yes.
Your lordship, impossible. It is really.
Your lordship.
We won't say anything today.
We are going as per
Adjourn the matter to 26.
We'll come up against those
Bas,
orders.
give no guys.
It's very difficult. We are
We'll file an SLP against them.
11.
tainted or untainted.
But this will appear on
In every.
26.
File an SLP against them.
With the other connect.
Will your lordships then place it at a particular time? Because High Court has flooded your lordships with these matters. They are
It's for them to handle their own boards.
your lordships, they are hair splitting
Lordship,
the
the state should
grounds.
move a transfer.
And all
Yes,
of
that
them
is-
have been decided by a lordship.
Lordship, the state.
It's coming up on 26 November.
Yes, sir.
26th year before my lord, 28th before the High Court.
Very well. 26.
But what do you say on top of the board if
No,
we
it
can?
will be
Very good.
26 is a.
We are going to just.
Yes,
We are
grateful,
also
madam.
filing.
Because it's imperative for the
They
lordships.
will got the.
No, let this come up along with the badge.
Diary number of that, kindly just, if it's possible, take it on 26 along with that. We are filing SLP.
You filed it, where is the
No,
post office?
today.
You've not filed it yet.
Tomorrow.
Calcutta High Court is listed on 28. That's why we are
Friday.
expressing
26.
urgency that 26, the matter must be taken up by the
26.
lordships. Very great.
Grateful, my lords.
Yes.
Now, physical appearances,
Yes.
Because your lordship
Agricultural land.
is being verified now. They filed an affidavit now saying that I
Did they?
state is filed an affidavit on record, brothers. It's filed on 21st November 2025.
21st November.
It's a just 2-page affidavit.
Yes.
21st November.
Affidavit in compliance. Is that the one?
Yes, sir. Para 2 minutes.
Does possess agricultural land within district.
They have produced a digital register, Millards. We had produced the handwritten register. That's the only difference.
How much land do you have there?
Here, 1.60. This is 60 are here.
Page 3 is the translated version.
60.
Page 6 is the original Marathi document.
60 hours.
60 hours. That's 6,000 square meters. 1 hour is 100 square meters.
Yes, sir. Around.
I must feel ignorant. I have ignorant. I will just take this up.
1 hour is 100 square meters. So 6,000 square meters. What do you say,
I
Mr.
pointed out last, all of this was placed before my lords at the time of
But
hearing of
the matter is going on, so how long can we ask him not to go into Pune district?
This is all the
If he has agricultural land there, are you in a position to say that he has other family members who can take up the agricultural operation?
that I'm not aware of.
Then if you're not, then we'll have to
He's
say.
clearly been handling
How
the
can
agricultural
we
lands
say that you have land but you can't use it? Livelihood of your family members also, you can forget about.
He's obviously been using the land for the last.
No, you
4
were,
years.
on the last occasion, you said he wants to go back to build up a political career or something like that.
No.
So that we will make clear that he will only
No
do
question, no
agricultural
question.
operations, nothing else.
No question.
No,
No
we then
Very well.
clarify that.
Miscellaneous application number 1970 of 2024. By way of this miscellaneous application, the petitioner in specially petition criminal number 4684 of 2023 seeks modification of the order dated 16/5/2023, whereby he was granted bail subject to.
It's criminal
several
appeal now.
conditions. Sorry, it's now appeal.
Appeal, Millards, because it was allowed. Millards. 1532 of 23.
In
Sorry.
criminal appeal numbers, please. Appellant in criminal appeal numbers. Granted bail subject to several conditions, one of which was that he would not enter into district Pune.
Pune.
Full stop. By way of this application, the appellant seeks modification of the aforestated condition on the ground that he has agricultural land at Koteshwar Wadi. Is that correct? Koteshwar Wadi.
Yes,
Koteshwar Wadi in Mawal. Mawal is what? Taluk of district Pune, and needs to enter into the district to carry out agricultural operations pending disposal of the trial has not, what is the
So
state?
charges are framed in 2022. After that, not a single witness has been examined.
Pending conclusion of the trial. The state verified. The state of Maharashtra filed an affidavit after verifying the claim of the appellant that he owns and possesses agricultural land and certified that he has this 1.2100. Is that what we should be? Where do you find this 61?
60 hours at page 3. Your lordship sees the translation on the left side, 60 hours. 60 hours plus is there.
There is. Certifying that the appellant owns 60 hours of agricultural land in, where are the details? It's no details.
Yes, it is there.
Next page, page 5.
Yes. Because there's the details of village and everything is mentioned.
Some survey number, something, Khata number is there?
Yes, sir.
Khata number is 969.
It's a village.
Survey number is.
Khata number is 969. In Khata number 969.
Gut number 181.
Where do you find that?
On the table.
Table below, right? Memorandum number and subdivision number. Just above the table. Page 3, just above the table. Gut number 181.
It says gut number or subdivision number?
I am reading from
Marathi.
It says gut number. In gut number 181. In that view of the matter, the appellant cannot be denied his means of livelihood by preventing him from putting his agricultural land to beneficial use for the use for the benefit of his family. The condition imposed in the order dated so and so is accordingly relaxed to the extent of permitting the appellant to enter into Koteshwarwadi, Mawal Tado, district Pune, only for the purpose of doing agricultural work. He shall not address any political gatherings, or you're a politician also?
No,
Joining politics.
Not even an aspirant. Not even
That is what the other side.
The entire reason why the murder happened.
I can tell you a lot of that. Having spent 10 years of time, I have the qualification, but
Now you have the
qualification, but no, not an aspirant. Not an aspirant.
Very good. That's all.
Grateful minutes.
$54.
Please, and just seek some time under the file count.
Counter. Then cancel for the petition, for all the respondents.
Malan.
For the respondents, seek some time to file a counter reference, usual order. Earlier, the order dated 22/9/2025 shall stand extended till the next hearing. List on 23rd January.
My appearance may be marked. I had missed the deadline. Right. Okay.
Item number 55.
My lord.
My
lords, we have received the private respondents counter yesterday. We will seek time to file a
No
rejoinder.
counter.
For other parties.
Counter.
We have sought instructions in the morning. We'll file our appearance and reply.
For which respondent?
For jail board respondent number 4, Your Lordship.
For the jail board.
This I appear for respondent number 5 to this element.
5?
Yes, sir. I
You're
appear.
appearing. You've not filed your counters. Who filed the counter?
I have filed it, my lord. I am in.
Only you filed it.
My lord, I want to bring certain.
When you appear as a party in person, you must not wear the full dress.
I know, my lord, but I was in this court only, so I didn't get
At
that.
least one. The bands you can remove.
Oh, okay. I'll do.
As a party in person, you should not be wearing the dress.
Okay, my lord.
Certain practices one must not.
I know,
discard.
my lord, but I was in this court, so I could not just keep doing it. My lord.
So you filed your counter. And you need to file your rejoinder.
My lords, we would like to file a rejoinder. We received it yesterday.
My lord, I would like to bring certain photographs of today morning, just which shows that the sewer lines are still overflowing since morning, Saturday.
You'll have to file it. Don't hand over documents across.
I have to just, since it was in morning today.
Find it then.
So
Anyhow, they
I'll
want to
file
file
it.
the
My lord, I
rejoinder.
wanted to just say one thing, since Delhi Jal Board needs to, clean the sewer lines which is overflowing. So the court which has given the directions of stay, they are not bound on them for.
They appear for the Residents Association. Now the impugned order, para 8 Roman 1.
Yes.
Milord's concerns directions only to the Delhi Jal Board and MCD to continue clearing
At least
But why are they not doing?
because there's a stay. My lord, there's a stay. From
Your Lordship's order is a stay of the impugned order.
Oh.
So that needs to be clarified, my lord.
Yes, That cleaning and all that you have to do. We only was state the laying of the sewage line through their residential complex.
My lord, that too.
It will be done for Jal Board, my lord.
Yes.
My lord, just one clarification.
Respond number
4
1 filed a counter affidavit. We are informed that respond number 1 filed a counter affidavit, but the same has not been placed on record. Registry is directed to verify the same. Then counsel for the petitioner seeks some time to file a rejoinder thereto. Respond numbers 4, 5 and 6. 4, 5 and 6. Then counsel for respond numbers 4, 5 and 6 seeks some time to file the counter affidavits. Usual order affidavit. We clarify that the stay granted on 27/10/2025 is only in relation to the direction of the High Court, permitting the direction of the High Court as to the laying of a sewage line
Within the 8
lines within the premises of the petitioner, All India Institute of Medical Sciences. The other directions with regard to cleaning and clearing of the existing sewage lines, be it by the Delhi Jal Board or by
MCD.
Municipal Corporation, New Delhi NDMC, shall continue to operate. And not MCD. MCD. Only MCD. I thought one was brought on.
My lord, NDMC.
It was stated that the land is in NDMC jurisdiction.
My lord, they have given a wrong information. AIM says that this land belongs to NDMC, which was not there actually. It is there who are
You can put NDMC oblique MCD. Whoever has to do it, do it.
No, MCD is the owner.
Your Lordship, in fact, para 8 Roman 1 of the impugned order records both BJB and MCD. The Lordship may sustain that.
That's what's been done.
Para 8.
Roman 1, Milords, of the impugned order, page 6.
We further clarified that the direction in para 8 within brackets small I of the impugned order shall also be given effect to.
Please. My lord.
It only says monsoon. Monsoon is over though.
No, my lord, it's throughout the year. It is today morning also. It is wrong to say it is monsoon. It is throughout the year.
Even at this stage, though the said paragraph only refers to the monsoon season.
My lord, a short date should be maybe given, my lord, because it's a
12th January.
My lord, can it be a little earlier, my lord, because the problem is too high there and the things are overflowing. If I can request, my lord.
The state, should we implement the Delhi state government also? It is better because this kind of direction it not to be.
As my lords.
I will first clarify, my lord, I appear for the Residents Association.
Delhi wants, the government wants to acquire any land that is for.
My lord, it is not acquiring, it's going underground. My lord, there's a misconception.
You can't say that you will do.
My lord, this land belongs to a public place, which is not, we are not taking any place, we are going trenchless. We're just going
It would perhaps save you time if the Delhi government is also before us.
They are already a party.
They're a party. Very well. Who is appearing for the government then? No one. Services are dictated.
Services.
Let's see. Public Works Department.
Respondent 7.
And Forest Department. Both are there. learned counsel for the petitioner is also permitted to effect service of notice upon the learned standing / designated counsel for the NCT of Delhi. 56 perhaps will not be able to take up today.
एक सेंटेज
Number देखना.
56 matters obviously jinxed. Whichever date we fix it for,
very kind to me,
whichever date we fix it for, the miscellaneous hearing tends to go on, or some.
I'm sorry.
Because of the oath ceremony, will not. Otherwise,
That's because otherwise would have reached today.
Whenever it's convenient for us.
Next Friday.
Lord, we are here to
Next
assist whenever it is
Friday,
convenient to
we have
bylaw.
a hearing.
Next Friday.
3 are there.
Take it on
I think this is.
19th is too far away. We'll keep it on 28th, or let us see. 28th.
Friday,
It's a Friday. We already have some hearing matters listed for that day. Hopefully, if they fizzle out, you can have your.
Obliged. Obliged.
Most obliged.
Obliged.
57.
57.
Please, Mullers,
7.
taking a short accommodation. My notes may keep it next week.
Permit is sought by the learned counsel for the petition. Based on 5th December.
Obliged.
Document 63.
To start here in 59, it's a fresh matter. And here we are requesting a notice and stay if it pleases the court.
You are a
Yeah,
third
just-
party to the.
Yes, so can I just say, the answer to that is yes and no. The reason why I say yes and no is because I am the plaintiff in the first suit which came to be instituted. You may just note the number. It is Civil Suit 1 of 2023. Now that's the civil suit number which carries the present name in the Allahabad High Court. It was instituted, please note the date, it's important, on 25th of September 2020. And it was initially 2020. It was
The suit number is 23.
Yes, because it was initially instituted before the civil judge senior.
Twice it was transferred to the
Mathura.
High Court thereafter.
Yes, thereafter, so what happened essentially was that I had instituted the suit, and this is very important from our perspective, and it's important from the court's perspective as well, because there's a huge amount of research, historical, archaeological, etc., which has gone into the institution of the suit. Now, after the suit was instituted, as I told you, on 25th of September 2020, there are several, what I would describe as cut and paste or copycat actions which were filed subsequent to the institution of that suit. Thereafter, at my initiative, we made a request to the Allahabad High Court under section 24 for the transfer of the suit. That order also came to be passed on my application, and the suits were consolidated and transferred. There is also an order on the record which shows that my suit has been labeled as the lead suit or the leading matter in the case. Now, what has happened, and my concern essentially over here is, as your lordship would have seen, there is a subsequent suit. That suit is 17 of 2023. And please just note the date. It was filed about 3 years later on 10th of August 2023. Now, in that suit, while all the other actions have been consolidated, what has happened is that the High Court at one point separated that suit from the other hearings. And here you will just find, you may please go if you're to page 284. Please just go to page 284 for a minute.
Yes.
And then I'll come to the issue, because according to us, the impugned order suffers from procedural as well as substantive infirmities. So your lordship has an order at 284. I'm not taking you to any great detail. Directly to 288, there's a list which you will find earlier of various suits which are pending.
Yeah.
Now in 288, I request you to please go to para 16. Since the original suit 17 of 2023, an application under Order 1 Rule 8, read with Section 151, is pending for disposal. Therefore, the issue of consolidation of this suit with another suit will also be taken into consideration later on. All right, so now that's a tentative observation. Now the next para. Considering the arguments advanced by the learned counsel for the parties and in the interest of justice, now this starts with my suit, original one, and there's a whole bunch, are consolidated. Your Lordship has that. Then para 18, suit number 1 of 2023, that is one of my suit, is described, is made the leading case. Your Lordship sees that as well.
Yes.
It is, however, made clear that the applications pending in the other suits shall be dealt with separately, etc. Now, 17 was segregated. If you see, go back to that paragraph 17. Please just go to para 17. You will find after the suit number 16 of 23,
18.
there is 18 of 2023. So this present suit, Your Lordship's question to me initially was, are you a party to this suit? So in a manner of speaking, I am the plaintiff in the lead suit. But am I formally a party in this suit? The answer is no. Now this suit was therefore, because it was not consolidated, it was proceeding in parallel. Now we come to the issue. I should just mention straight away, Manoj, that I had at one point of time taken out an application under Order 1 Rule 8 myself in my suit, and that I withdrew with liberty, and that was granted. But just keep that aside for a minute. Now please go to the prayer because the High Court in the impugned judgment also has something to say. Please see the prayer in the present application at page 240. So the application itself may be first placed at page 220 if you want to see the opening.
Yes.
So this is the application in order suit number 17 of 2023, P10, begins at page 20. And I take you directly to page 240, directly to 240 in the prayer.
Yes.
Now, this was amended. This was amended slightly, which I will inform the court about. Your Lordships have a prayer. May I place it? It is therefore prayed that the plaintiff, Your Lordship has that, be permitted to sue and deal the suit as representative capacity against the entire Muslim community of Mathura, suit under Order 1 Rule 8, read with section so-and-so 151 as well, and any other order we also passed as this Honorable Court deemed fit and proper. Correct? Now, the amendment was that as against the entire Muslim community of Mathura, it was amended to make Muslim community of India. Just please keep that in mind. So, it is an application for in a representative, to make it a representative suit on behalf of defendants. That's very important. Now, just go to the impugned order.
What was your Order 1 Rule 8?
Sorry?
Your Order 1 Rule 8, which you withdrew.
Yes, therefore,
was it on the same lines?
So, it was slightly different, but I might just inform the court. We've got that application, and I've actually filed an Order 1 Rule 8 in this court as well. But just have a look now as to what the High Court has done, because we have an issue on this, and then I'll just place my points.
Yes.
Now, please go directly to page 17, which is part of the impugned order, at page 38, paragraph 38, I'm sorry, paragraph 38.
Yeah.
May I just read the operative direction first and then go back to the reasoning?
Right.
So just see what the court does first in para 43, and then I'll go back to the reasoning from para 37 onwards. Page 19, Manoj. As prayer made in application Order 1 Rule 8 appears to be somewhat ambiguous. Therefore, the relief is liable to be modified in the operative order in exercise of power under Order 1 Rule 8 1B vested in the court in the following manner. In the application under Order 1 Rule 8, CPC is allowed in the manner that the plaintiff is permitted to sue in representative capacity on behalf of the benefit of all the devotees of Lord Sri Krishna who may be interested in the suit against the defendant number 1 to 6 and entire Muslim community of India. I'll read on. Let notice under Order 1 Rule 8 1A CPC be issued within 15 days in national newspapers at the plaintiff's expense to all the persons so interested in the suit. Pursuant to this order, the plaintiff may move separate applications, seek consequential amendment in the plaint wherever necessary. Now, let's just go back to this, please. 43.1. Application under Order 1 Rule 8 is allowed in the manner that the plaintiff is permitted to sue in the representative capacity on behalf of and for the benefit of devotees of Lord Sri Krishna who may be interested in the suit. Now, I'm pausing here for a minute. You remember the application itself. The application was for Order 1 Rule 8 defendant. What has been allowed here, it seems to me, I don't know, it's there may be capable of some other interpretation. And then it says who may be interested in the suit. And then against defendants 1 to 6, entire Muslim community of India. So they are converted, order 7, in this application, suit 17 appears, at least on one way of reading it, is representative both on the side of the plaintiffs and representative on the side. So my first point is that, look, when you have a situation where you have an application which is restricted only to the purposes of defendant's representative, I don't believe this can be done without proper notice which the court gives. Now, why do we have an issue on this? The court is completely aware that all these suits have been transferred to the court. So there are already more than a dozen suits which are pending before the court. So the whole thing on the basis of plaintiffs, on behalf of the plaintiff to make it a representative action is already an action which is there, which is present. Suit 1 of 2023 has been marked as a lead suit. So in a situation like that, without giving notice specifically to the plaintiffs, if you're converting this application, according to us,
the learned judge not aware of the pendency of.
Of course, he's aware of it because he's the one who's they have passed the order. My lord. These are original. Sorry,
is it the same learned judge? No, it's
yes, my lord. The matter, because the matters are proceeding, the matters are completely aware. But my lord, so just see this. Now just go back to page para 37. I'm part of the impugned order.
Yes.
Para 37. Page 17. Thus, on a perusal of the prayer clause in the application reveals that the plaintiff have prayed as being permitted to file a suit in representative capacity against the contesting defendants as well as the Muslim community. So there he recognizes defendants. However, defendant number 1 to 6 have denied the fact that in their objection they represent the entire so-and-so community. Defendant number 1 is the committee in the care and management of so-and-so and does not represent the Muslim community. The answering respondent has not sought relief by the court to defend or be sued on behalf of the Muslims of India, and hence it is not to be treated as representative of the Muslim community of India. If we go through the prayer, in the amended prayer clause in the application, it is clear that the plaintiffs have sought permission to sue and deal with the suit in representative capacity against all persons of the Muslim community of India, including the contesting defendants. It cannot be inferred from the prayer clause that the plaintiffs seek to sue and deal the suit in a representative capacity on behalf of and for the benefit of the persons of the Muslim community having the same interest. No other inference can be drawn from the perusal of the prayer clause. Otherwise, it will lead to absurdity. Although the prayer clause in the application under Order 1 Rule 8 CPC is not happily worded, yet on reading the pleadings and as contained in the application, the intention of the applicant becomes evident. I'm just pausing here. This has a huge impact on all those other suits, and none of us were before the court in the sense this was separated. Your Lordship saw that earlier order which I mentioned. Now, when there is a lead suit, which Your Lordship saw that particular order as well. This is an order at page 284. I had placed before you 288. Now, suit number 1 of 2023 made the leading case, paragraph 18. Then if we were to make it a plaintiff suit, representative suit on behalf of the plaintiffs, it would have to be the leading, it ought to be the leading suit. Because this is the suit which has done everything. Everyone else is a copycat and thematically has taken, broadly the issues. So this is, Lord, a very, very serious part because first of all, there's no prayer in the application. The High Court also is recognizing that it is only a defendant's action, a defendant's representative suit. Then in the final operative direction, which I placed before you in 43, converts it into both plaintiff as well as defendant. I'm not saying that the court doesn't have the power to do so. It may have the power to do so. I think on my reading of Order 1 Rule 8, it does. But then there's a process to be followed. The process would certainly involve specifically putting Order 17, suit number 17 along with the others, hearing all those plaintiffs, and then coming up with a solution as to which would be the appropriate case to make it Order 1 Rule 8 on the plaintiff side. And again, of course, on the defendant side. Now, this your lordships have held it's a very nice expression which our court has used, a two-way street. Please just have a look at that, my lords. Give this judgment. Yeah, come on now.
2022.
Why are you? Please, one more evidence I asked for.
Page 138. 138. Two judgments I asked for.
Who is on caveat here?
No, so I appear for respondent number 1.
So there are some other matters also on this side. With your lordship.
There's another matter also. That you're in another suit, perhaps.
Yes, yes, my lord.
They're in one suit, you're in another one out of those 15 suits.
This may, according to us, require some.
Both of you are the plaintiffs in two of the other suits. And who's on caveat?
So I appear for respondent number 1.
Who is respondent number 1?
Lord, it's the Shahi Masjid committee.
Oh, you're for the Shahi Masjid.
Please.
And?
We are for the plaintiff in 17.
In the other one.
Other suit.
I believe this will require some consideration by the court. Just have a look. Yes, sorry.
Yes.
Two applications have been filed by the other side yesterday itself. They may not be on record, wherein they are seeking the same prayer which they are opposing by view of the SLP Malad.
Sorry? I didn't understand.
They have moved an IA yesterday.
Who has moved?
The petitioner.
Oh, they've moved IAs.
Before
the
Before your lordship.
That's exactly what I started by saying. Because I am saying if I am the lead,
you would want to be the.
Yes, if it is to be done, there has to be a proper process which is followed. You can't have some copycat suits which suddenly come out in this manner. Now just have a look at our court is very.
Somebody who has to join cause with me is joining issue in Supreme Court. We are all plaintiffs.
Of course.
Very surprising. They were given opportunity to file a counter in my order 1 ruling. They did not file a counter. I show the orders.
You know,
how would they be given an opportunity?
They were given because they raised an issue. Please see, there's an order passed.
Anyway, now let me complete.
There is an order passed by the High Court giving liberty to the defendants in my suit and the other plaintiffs whose suits were taken away and
there's a specific order.
A specific order, page 290. They don't avail of it.
Anyway, we'll see.
And the 290.
My lord, objections, my lord, what they are saying.
Before the High Court.
Exactly, my lord.
Not considered.
No, they argued also, and this petitioner didn't file.
No,
Page 290.
my lord, please allow me to submit.
Please see para 3, my lords. Yes. The objections against application
plaintiffs in other suits.
By the defendants and plaintiffs in the other suits. Counsel for the other suits who desire to file objections against the application obtain the.
But how would they be put on notice? They are not parties.
There was a public notice. There was order passed. Notice was given to them.
My lord, please allow me.
And they appeared and argued the matter. Please see the interview order.
Not all of them, though.
No, my lords, we have filed. Please allow me to submit.
No. What about your client, Mr.
They did not file.
You did
No,
not.
so I was just in the midst of my argument and just placing.
Because this is something that perhaps affects your argument also.
No, my argument.
Because your argument was that you were not there at all before this.
No, my argument.
But you were put on notice.
No.
You were asked to
Can I just can I just respond to that? The prayer in the application which I have placed before you is a prayer for defendants. That's why I was just showing you the judgment. It's not a prayer or relief sought on behalf of the plaintiffs. That's my primary concern. That I am
put on notice that the court was.
No, it's not, because look at the prayer, my lords. Look at the prayer. And the court also recognizes that as a prayer. The amendment also makes the. So once you have a particular relief, I am, as far as I am concerned, as far as the plaintiff is concerned, in the lead matter is concerned, I feel that there is going to be no trammel as far as my conduct of the litigation is concerned.
To that extent, Mr.
Yes,
Devan has a point.
That's one point. Which needs consideration.
I have something to say on that.
Okay.
Questions before the High Court, please allow me to submit. I'll clarify. My lord, when the suits were transferred, 16 suits were transferred in May 2023. After the transferring of suit, this OSUT 17 was filed at that time. So, my lord.
Directly before the High Court.
No.
It was also transferred.
Yeah, District Mathura Court, but it was being transferred later when the trial has already started. So now, my lord, the point is when the Order 1 Rule 8 application as a representative suit is supposed to be filed, it was to be filed before the suit is to be registered. So here, my lord, when you can see, they have just filed it later along with the suit was registered, and they have filed this suit as a next friend. Because the minor is it is always a minor, and a minor cannot be represented through a representative capacity. It can only be representative through next friend, my lord. So now, my lord, here as a next friend, and as being the representative of the DT, how you can become the representative soon? And then also without, after asking to amend the prayer, even the order clearly read what my learned senior has just read, it was clearly about the diversification of the benefit which they are seeking. And apart from it, my lord, the private defendants 2 to 6, the private defendant of OSUT 70 are the private Muslims against which there is no cause of action. Their claim doesn't show any sort of cause of action against the private defendants. So how the private defendant can become the representative of the Muslim community?
What are these applications that you have filed? They've not been put up, is it?
And my lord,
Yesterday?
Just the applications, my lords, are
Just two things, my lords. Just two things. First point, we pointed out, my lords, they were given
Who are you appearing for?
I am, my lords, the
You are the plaintiff.
plaintiff.
Oh, you're together. And you are for the
R1.
R1. Now,
That's all, three of you? Anybody else?
yeah, I think that's.
over here directly.
Therefore, the first point on no notice, no knowledge goes. They had notice, they did not file objections. Number one. Number two, I think my friend will bear me out.
Very well.
Now, number
It's
one.
better that we hear you on perhaps Monday then.
Very well.
All right.
We'll just adjourn the matter.
Very.
Just on Monday.
Yes. Even the second point, my lords, once he argues, I'll point out.
Yes,
It really doesn't subsist, I'll point out. Page 18 is a complete
What
answer.
was the observation you wanted to read out from this?
No, I'll place it. Thank you.
Would your lordships then consider having it in the second week, commencing from 8th of December?
No, we've not issued notice yet.
Just very
We will just hear the matter.
Well, just hear it whether you want to
Sorry,
consider it.
4:10 now.
Yes.
Yes.
And this matter perhaps would require some amount of.
Yes.
That's true.
So it will come up on the fresh list and whatever, next Monday.
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 We'll take it up at the end of the list. though.
Very good.
Great.
All right.
Grateful.
End of the list.
Very great.
Lord, I am seeking short accommodation, Lord. Lord, in next Monday, maybe list.
Adjournment is sought by the counsel for the petition. Interim findings.
Lord,
List on 5th December.
my Lord, next week, my Lord.
Next week only, 5th December.
Great, Lord. Great.
That's item 62. These were an application for transfer of the bench under 408 of CR. My lords, both the courts have dismissed my application. My lords, may
And we don't have the order also.
yes, my
Not
lords.
uploaded according to.
Yes, my lords.
Then
Now the issue
Look
is,
at the sessions judge's order, session judge's order.
my lords,
Page 39.
yes, my lords.
Then
My lords, may kindly have page 40 of it. My lords, I will show
you
the.
agreed before the sessions judge that you had no issue with the presiding officer.
My lords, I don't have issue regarding the
Then-
integrity of the.
Well, he says that the presiding officer shall deliver a judgment now. The
Now,
sessions
my lords,
judge-
may kindly.
Now you want to stay because the judgment might be pronounced.
No, no,
You
no.
have to
My
make
lords,
up
I have
your
a
mind
bigger
what you
issue.
want.
My lords, I have a bigger issue which the trial court has agreed to, but they have not taken any actions. My lord, may kindly have P1, my lords. My lords,
I'm not going to interfere with this. On one hand, you say you don't want the judgment now. You're asking for stay on the ground that the judgment might be pronounced.
no, my lords.
And then you go before the sessions judge and say that I have no issues with his integrity.
My lords,
He's not delivering a judgment.
No, my lords, there are other issues. My lords may see the procedure discipline followed.
If the presiding officer repeatedly gives, this is the observation of the sessions
Right,
judge
my lord.
perhaps, but your argument was, arguments were, you are the applicant, is it not?
Yes, my lords.
Then you said that arguments were presented. He was heard only once by the court. He has no apprehension or fear regarding the presiding officer. So the comments were also called for from the presiding
Right, my lords.
officer.
My lords, I will.
Due to heavy workload,
Yes, ma'am.
a decision was not delivered. So now let the decision be
My
delivered.
lords, my lords may see what they
After
have
the stay
done.
of the judge.
My lords, when the arguments were completed, the trial court, the learned judge, had put up the matter for evidence of the complainant. There are 5 exemptions continuously allowed to the accused. In the
All that is over
comments,
now.
in the comments, the learned judge has said,
Considering
at-
all the
at the-
circumstances, PO is expected to deliver his decision on the date fixed for the decision. No undue adjournment will be granted. So let that happen now. Why should you again try to stall that process?
my lords,
Having
because my
obtained
lords,
this
we
order
see how the proceedings are being conducted, the
Sorry,
leniency.
we don't even know what the High Court said because there's no order also. We find no good ground and reason to interfere in the matter after perusing the order passed by the learned sessions judge on
My lords, 15 September 2025.
on 15th September
15/9/2025.
September 2025 as the impugned order
My lords,
passed by the High Court on 19/11/2025 has not even been placed before us.
My lords, it has
The
not been
petition is accordingly dismissed.
My lords, may at least allow me till the impugned order is here.
No, nothing else.
Great, my lord.
Wait, please, my lord.
Yes.
The High Court does not examine the merits. It states that I have an efficacious remedy in a discharge. In paragraph 6.
But Mr. Dave,
Yes, my lord.
what is more worrisome is the reference to the judgment of this court.
Yes. The judgment is not.
Neeta Singh.
That judgment, my lords, is not applicable. My lords. What is
How is it not applicable? That is directly on the point and says that filing of a charge sheet is sufficient to dismiss a quash petition.
There is a judgment of your lordships, my lords.
Exactly.
2019, which says that filing of charge sheet.
2019, in fact, sitting with Justice Bose, I authored a judgment, a 3-judge bench, no less.
Yes, my lords. Abhishek.
Yes. But that is not brought to the notice of the division.
These are not brought by anyone. The court has placed reliance on with respect.
No, but this Neeta Singh refers to that Radhesham versus Chabina, which is the 227 judgment.
That's the point, my lord, but we didn't refer it.
The difficulty, I'm not blaming you. But here the advocates need to take a little more trouble to at least tell the bench what judgments are there on the point.
My lord, may I just pass on something to your lordship? I didn't want to say this, but please pass this on. This is an order, my lords, which is in a particular form, my lords, with respect. On top is an order, setting aside that order of your lordships, my lords. Just please have the 6th page, my lords, which is the, again, of the High Court.
Sorry?
6th page, where it says in the High Court, my lords. Now, please see this order, impugned order, and see the impugned order here, my lords. Except Neeta Singh, everything else is the same. And therefore, your lordships were pleased to set aside this order and remand it back and ask the High Court, my lords, to decide it on merits, my lords. Paragraph 5, at the first, at page 2. So we faced this problem many a times, my lords. I know my lord had been the Chief Justice there, my lords, all that, but this problem is there, my lords. This order. Now, it's a simple thing. Decide it on merits, reject it on merits, my lords. I'll come now. It will come here, my lords. Go back to the High Court, my lords. That's what I'm praying for, my lords. And your lordship's judgment is there. Justice Bobde's judgment is there, which says.
I refer to two earlier judgments in that judgment.
We refer to them.
This Neeta Singh doesn't refer to any judgment on the point.
No, it doesn't.
It extends the 227 judgment, and nobody informed the bench that these judgments are there. There's a judgment of a 3-judge bench.
These are by the bench itself, my lords, with respect. These are by the bench itself. That's why this is not placed.
Nagamuttu appeared.
No,
in Neeta Singh. In Neeta Singh, Mr. Nagamuttu appeared, and he doesn't inform the bench of the judgments which are directly on the point.
I don't want to say much.
Issue notice.
Because my next date is 23rd January, my lords.
5th January.
Lordship, please.
The affected owners.
Grateful.
Lordships are issuing notice on the stay application also.
On the stay application.
So great.